Go ahead.
Thank you. This is a case for non-payment of rent. Rent to retain possession is $3,100. Court costs are $175 for a total balance of $3,275. Plaintiff is asking for a default judgment for possession only with a writ to issue after 10 days, which I have is after September 8th, 2025.
Judgment to the plaintiff, that is by default for possession, redemption amount in the amount requested, writ to issue in 10 days. Del Virgil Properties versus Courtney McCoy.
Jillian Engen for plaintiff.
And Keith Rutley. Okay, there's Mr. Rutley. Hello, sir. All right, what is plaintiff's claim in this case?
I have a balance including court costs of $2,620.
All right. Sir, how are you guys intending on getting that paid?
Well, what happened was I got laid off from my job, and my girlfriend was trying to pay it by herself, but she's doing as much as she could. And then she got sick. Our whole house got caught COVID, so we were off for a month. And I'm trying to get unemployment. I actually just had a hearing the other day, I think 2 days ago, about getting my unemployment back. But we're planning on moving. She just got approved for Section 8 housing in Monroe, and we can't move.
So you're moving?
Yes, and we can't move until the 19th.
The 19th? Okay. What I'm going to do, what is my adjourn date?
Your next adjourn date is going to be the 5th, September 5th.
All right. What I'm going to do, sir, if you were intending on moving, then you can certainly arrange and move. You're entitled to a week to try to see if you can get financing to get this or get assistance to get this paid. I'll adjourn this to September 5th, 2025 at 12 noon. All right. And we can see where we can go from there. I might suggest if you've got the 19th that you contact counsel and see if you can arrange a move out date so we can get this taken care of.
So is there a way that we can also set up a payment plan, or I just got to go through the actual?
I think you can do that also with them.
Mr. Rutley, if you want, you can call the phone number under James Fink on the court paperwork and leave your name and your number and email, and then we can get in touch with you.
Okay. Thank you.
Thank you.
All right. Thank you, sir.
Yeah.
Have a good holiday.
Have you too.
Evergreen Apartments versus Christine Baker.
Jillian Engen for plaintiff.
She here.
Yes.
Ms. Baker?
Yes.
Okay, there you are. I was trying to pick you up on my screen. All right. What is the claim in this case? This is termination?
That is correct. The notice was sent for housekeeping concerns leading to a pest infestation. It's not relevant to the reason for the termination, but I believe Ms. Baker's voucher was terminated as well.
All right, Ms. Baker?
Yes.
What's your position on this termination case?
Well, it's been a problem since I moved into that place. RPI has been asked them to spray, and they're spraying what they have done hasn't done anything. It's just multiplied more. I've been frogging myself, trying to get rid of the problem.
Okay.
Your Honor,
Yes.
it's my understanding that the housekeeping issues are preventing the home from being effectively treated.
Because it's not properly prepped. Yeah, I
That's
kind of
correct.
picked up that. Okay, Ms. Baker?
Yes.
Are you gonna talk to an attorney to try to get you to get some help with this case?
I couldn't hear you. I'm hearing impaired.
Okay. Are you gonna get an attorney?
I'm trying to listen.
Okay. Are you gonna get somebody to help you with this case? Like an attorney, a lawyer?
Yes.
Yes. Okay.
Because,
I'm gonna give you one.
Go
ahead.
My CMH worker has told me today that my voucher is active.
Okay.
Okay.
So why don't you give legal services a call? Okay. Maybe work through your CMH worker. Okay, and I'll adjourn this out 1 week for you to get that done, okay?
Okay,
So it'll be September 5th at noon.
my, the CMH worker, she's gonna be out Monday there and to talk to me.
Okay, so I'll adjourn it to next Friday at noon. And you'll need to come in to the courthouse and be here in person, okay?
Okay.
All right, we'll see you then. Thank you.
Mhm.
Evergreen Apartments versus Wanissa Matthews.
Jillian Engen for plaintiff.
Don't purchase it.
Wanissa Matthews? No response. You may proceed.
Thank you, Your Honor. This is a termination of tenancy case. And Ms. Matthews sent plaintiff a notice to vacate on 6/3/2025, saying that she wanted to terminate the lease and not renew it. So the lease expired on August 3rd, 2025, which was the date Ms. Matthews gave for her notice to vacate. And so she has not returned possession to plaintiff. At this time, we are asking for a default judgment for possession only with a writ to issue after 10 days.
Judgment to the plaintiff, that is by default for possession, no redemption amount, writ to issue in 10 days. Evergreen Apartments versus, is it Francely Renedas?
Jillian Engen for plaintiff.
Not checked in.
They are not checked in, you may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent to retain possession is $3,296.68. Court costs are $172 for a total of $3,468.68. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days.
Judgment to the plaintiff, that's by default for possession, redemption amount, any amount requested, writ to issue in 10 days. Evergreen Apartments versus Charlotte, is it Jamira?
Jillian Engen for plaintiff.
Is Jamira? Oh,
Hi,
there you
can you
are.
hear me?
Oh, we can hear you. You need to turn on a camera, please. And
Okay,
while
my
you do
phone, I
that,
don't know if,
pardon?
I don't think my phone will have a camera.
right.
Oh wait, here we go.
Okay, what is plaintiff's, while she does that, what is plaintiff's claim?
Your Honor, I have a balance including court costs of $1,430.37.
All right. And Ms. Jamira, when are you gonna get that paid?
So I can pay like $500 on Monday, but I have an interview today with another job. I currently have 2 jobs. I'm working extra hours right now to cover it. I know that it's going to roll over next month, so I'll have more to pay. So I'm just hoping to make it before the end of the month.
Before, to pay it off before the end of September?
Yes.
Okay, you're gonna have to arrange something with the plaintiff. What I'll do is I'll adjourn this out a week for you to either seek some assistance or try to see if you can get some of this paid down. But pay the $500 on the 1st. I will adjourn it out to September 5th, 2025 at 12 noon. Okay?
Okay.
All right. Thank you.
Thanks. Bye.
Evergreen Apartments versus Dion Stevenson.
Jillian
And
Engen, sorry.
it's a Rayona Tubbs.
Jillian Engen for plaintiff.
Okay, Mr. Stevenson's here. What is plaintiff's claim?
I have a balance including court costs of $3,859.99.
All right. Okay, Mr. Stevenson, how are you guys gonna get this paid?
Well, I had contacted Hawk already, and I have a appointment with them on September the 9th. And I also did my SCR application, and DHS contacted me right before this court started, and I told them I couldn't accept the call right now. So they said that they're trying to schedule an interview for me.
Okay. What I will do, given all of that, is I will adjourn this out to September 5th, 2025 at 12 noon. Understand that at that time, your September rent will have clicked in also. So the other thing that you're going to need to do is in your paperwork that you receive from court, there is a rental assistance form. You need to fill that out. Drop that to the court by next Wednesday. Okay.
Okay.
That will, and you have to make sure that your tracking number for your SER is on there.
Okay, Your Honor.
Thank you.
All right, thank you.
Court calls the case of Evergreen Apartments versus Damani McWright
Jillian Ingen from
And-
plaintiff.
and Linda Logan. They're both here.
Sir, come on.
What? I really want to have it well, but we said it kind of I think we fled it. In fact, I'm almost positive we did. Right now.
He's already pleaded guilty.
Yeah, I think it was reset because there was some risk and we reset, but it was only like a few days.
Any flexibility we could do about it? Is there another case that he's supposed to plead?
Mr. Boyd, are you on this one?
Yes, Your Honor.
I believe Mr. Laird took the plea. No, Mr. Ham, I'm sorry.
What's your final answer, David? What's your final answer?
How many choices? And I believe it was Mr. Ham.
We now call 24 CR 2392, the state of Texas versus Keeler Ivan Maldonado. That is you, sir?
Sir.
Present with your attorney, Mr. Grove, and the state's attorney. Earlier, you pleaded guilty to the first degree felony of aggravated robbery. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? Are there any corrections or changes to it?
None from
Stay.
Your Honor.
Well, what about me?
Your Honor, I reviewed the report with Mr. Maldonado and the defense says no changes to make to the report.
Then the pre-sentence report is made a part of the record for all purposes. The agreement is whatever sentence shall not exceed a cap of 12 years in prison. So we are looking at no less than 5, no more than 12 years imprisonment. Regular probation is not an option because a deadly weapon firearm was used in the commission of the offense, which gives the only other option to be deferred unadjudicated probation, which can be up to 10 years in length. I think those are the 2 options, correct, everybody?
That's correct.
That's correct, Your Honor.
All right. Go ahead, Mr. Grove, on behalf of the defense.
I'm going to be very brief, Judge. I believe that this is a very unfortunate thing that Mr. Maldonado was involved in.
Certainly was unfortunate for the victim.
Well, and it's unfortunate for Mr. Maldonado and the other folks that were there because there were a number of other people that were at least present. But I think based on Mr. Maldonado's past, and when I say his past, that's the lack of a past where he has had no prior felony convictions. He has been very good as far as things goes until this deal here. And this was not in any way justifiable. But I believe Mr. Maldonado realizes that this could have been the biggest mistake of his life and that he isn't going to let it happen again. He also dropped out of school before he got his high school diploma. And I believe he realizes how important that is. At the time when this occurred, he was employed for the city of Port Arthur. So he was working at the time, but this is just very regrettable. And I believe that he realizes that. And if the court were to grant him deferred adjudication, I believe that would be in the best interest of everyone involved, and I ask for the court to do that, grant him a deferred adjudication.
State, what do you want to say?
Your Honor, obviously it's a very serious offense. However, it does appear from the facts and reading it that the defendant is not the one who actually pointed the weapon at the victim in this case. Obviously, we know that doesn't absolve him from that, but it does appear he doesn't have any other history. I don't think we would necessarily, in this case, be opposed to a deferred, but obviously, in the court's discretion, this did involve robbing a young man at a park that had pulled a gun out on him. And I believe after he told him, no, I'm not, going to give you my chain or whatever, they ended up leaving at that point after initially threatening him. And they were found shortly later in a parking lot. And there was a gun in that vehicle.
I believe that's true. There was no restitution, Judge, although if there was, it certainly we would be willing to pay that, but I don't believe there was any loss suffered.
Y'all read the pre-sentence report and the probable cause affidavit? It's completely different from what you're telling me. He was the one that came out with the rifle. He's the one that pointed the gun at the chest of the person. The others were all juveniles. He was the only adult in the group. That's what's clear in the pre-sentence report. And that's what's clear in the probable cause affidavit. Maldonado approached Contreras, demanded him to give him 2 necklaces that were worn by Contreras. During the time, Maldonado pressed the muzzle of the rifle up to the victim's chest, but he still refused to give him his property. After that, several other subjects in the gang of thieves exited his vehicle and came up to the lone victim who was helpless and demanded and threatened him to give up the necklaces. He still refused. Then the defendant and the others left. He was the only adult in the group. The other 4 juveniles are being processed as juveniles. Now, his version. I was with some other people. We stopped at a park. We saw this guy. We robbed him. They passed me the gun. I just went along with this, even though I didn't want to. So much for taking full responsibility. That doesn't help him. He can't even tell me the truth. He can't even tell the truth. At this stage, when he's got everything to lose by not telling the truth. All right.
Yes, sir. I would point out that he did
12 years in prison. If I sentence you to 12 years in prison, you can't get out until 50% of it is served, at least. You'd have to be there for at least 6 years. Do you understand that? You want to tell me the truth about what happened now, or are you going to continue to lie?
Sir, like I said,
I'm sorry.
I'm not lying, sir. Like I said, we went to the park.
Who stuck the gun in his chest, sir?
Who, me, sir?
All right. It's not what everybody's saying here. You were the oldest in the group, weren't you?
Yes, sir, I was.
Well, you know, had you fired the gun into his chest and killed him, there'd only be two choices. The death penalty or life without parole. Those would have been the only options under license. Really? You thought this was a wise idea? Why'd you pick on that guy?
Wasn't much, sir.
Sir? Why'd you pick on? Was he just the most helpless person you could find?
I'm sorry.
The most vulnerable person?
Yes, sir.
What?
I don't know. It's just wasn't.
Anything else?
No,
I'm still a little unclear about the state. What's the state asking for?
Your Honor, them not having the history, obviously it's very serious, would defer to the court, although I don't know that we would be opposed to the deferred in this, where he'd be facing the, obviously, the maximum range of punishment if he decides to screw up at any point in this.
Anything else? Anybody just say?
yeah, certainly with the regular probation being eliminated by the state, by the law, not by the prosecutor. If Mr. Maldonado does screw up, the court has a much wider range of things he do. I think this will be the last time the court will see Mr. Maldonado. I think his background, although he has not been perfect, and in this case, there's no doubt that this is not justified. Mm-hmm. I believe that for whatever reason, he decided to do this before he had any other criminal history. And he wants to make a success of his life, and will be able to do so. And if he doesn't, then he's looking at 20 years in prison that the court could sentence him to.
How's that?
It'd be 5 to 99 or life.
How's that?
Oh, I'm sorry. I'm sorry. 5 or 99. The court could be looking at giving him 99. I apologize. I was thinking it was second degree, but it's not. It's a first degree. He could get up to life in prison if the court decides to go ahead and revoke his probation.
Do you have any family here?
My parents.
Your parents?
Yes, sir.
And they did it all here in their prison. And I apologize.
Where did the guns come from? Where did the rifle come from?
It wasn't mine, sir.
I'm going to ask you one more time. That wasn't the answer to the question. Because the answers you've already given haven't been truthful up to now to the probation office or to us.
Came from a friend, sir.
Who?
One of the people.
What's the friend's name? They got a name? It's a friend. You know the name. I know all my friends' names. What's the friend's name? Don't look at him. Look at me. When you do that, that means you're trying to lie.
Daniel.
Huh?
Daniel, I think.
What's his last name?
I'm not sure.
No. How long have you known your friends?
I met him for like 2 months, maybe.
Where'd you meet him?
Off of another friend.
2 months ago?
Like 2 months I had met him.
I don't understand what you're trying to say.
No,
2
I
months
had
ago?
No, not 2 months ago. Like I had known him for like 2 months.
Oh, when this had happened?
Yeah, like.
When this event happened?
Yes, sir.
Where did you meet him?
Where did I meet him?
I asked you first.
Off of another friend. Like I met that friend off of another friend. It makes sense.
So how did this firearm thing come up? How did that?
We was all together at first. Like we was just together, and then we went to the park.
Well, why were you selected to stick the rifle in the child's chest?
Sure, sir.
I wasn't there. You were there. You know what happened.
Sir.
Think about it while you make up a story.
Just,
Okay. Anything else?
no.
All right. The agreement is a cap of 12 years. That's the most you can receive. 12 years in prison, no less than 5 nor more than 12 years confinement in prison. Do you understand?
Sir.
All right. The court has reviewed this fully and has read the pre-sentence report and have you ever used drugs before?
Before, yes, sir.
Mm-hmm. When?
I
How
would
old were
say
you?
like around my 16 to 17.
You were 17 when this happened, right?
Yes.
You were almost 18.
Yes, sir.
Is that right? Or
Yes, sir. Thanks.
no, you had turned 18 by 1 month. Your date of birth is October 6th,
Yes,
right? Of 06?
Yes, sir.
Okay, this happened November 2nd, 24. So you would have just turned 18, right?
Yes, sir.
Anything else?
Nothing to say, Your Honor.
Here's what I'm going to do. The cap is 12 years. Stand by. Today in prison. And
Coffee's gone up so much.
Joe, coffee went up in price today.
Seems like I heard something.
Coffee's gone up so much.
Just about terrible. I can pay it off in a few years, Robin.
It's going to take that long. You drank all the coffee in your last trial. That's what you ordered. Come on up here. All right. All right. You don't want to be in there, do you? 6 years at least in prison. And you were in there by yourself. I mean, they got 4 more meaner people in the prison facility than you can ever imagine. Live with them for 6 years. Good luck. All right, this is a terrible thing you did. You should know, you know better, and shame on you for that. I'm going to find you have pleaded guilty voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes, sir.
There's sufficient evidence from State's Exhibit 1 admitted at your plea hearing to support your guilty plea to find you guilty beyond a reasonable doubt here. However, the court is going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years. You better do well. Everything is writing on that. If you fail to complete and follow the terms of your probation can be revoked. I can then find you guilty, and then you can be sentenced up to life imprisonment.
Yes, sir.
You understand? All right. Now, how far did you go in school? You didn't graduate. You're going to complete an educational program for high school equivalency, GED. There will be terms and conditions of probation, such as completing a moral reclamation therapy program. That is a program that helps you understand and appreciate when you victimize people. You just don't walk away from it. You have to empathize with the people you harm and try to help fix the mess that you make. This is all about growing up and being responsible. You should have known this at your age, that sticking the gun in somebody's chest and stealing stuff from them is serious. You have the control and the power, not them. And that's not the way the Creator meant it to be. You're not supposed to take advantage of people. You will have no contact with the victim or anyone on behalf of the victim, such as family members. And that is by telephone, social media, through a third party. You will avoid all association with the co-defendants in this case, the 4 others. There are 31 conditions here, but most of those are the requirements all of us have to follow. Don't commit crimes. You will have a curfew. You're going to act responsibly, or else you pay a serious price. You also can't stick a rifle in somebody's chest, threaten their life, and steal. You're going to go to jail for a little while. I can place you in jail for up to 180 days. Do you go to school? What grade did you complete? Did you complete high school?
11th grade, I'm on 10th grade. Dropped out.
Why?
Just want to start working.
Did your parents condone that? You know what that means, condone, approve of that?
Approve of that? No, sir.
So you went against their wishes?
Just didn't want to go to school.
Yeah, well, you guess what? You're going to go to school. Like it or not, you're going to get an education. It makes you make wise choices. You can see the foolish choices you've made while you haven't been going to school. Education is a wise thing. I made that up, but it sounds like it was the right thing to say. But it helps you make better choices. You're going to complete your high school education as a condition of this, like it or not. I mean, how I have to force somebody, threatening them with life imprisonment to complete your high school education sounds like a Twilight Zone episode. It just doesn't make any sense. It's off the grid. But This is conventional behavior that works. All right. You're gonna have to do 180 days and I will decide when you've had enough. You will do this on weekends. You will check in on or before 6:00 p.m. on Friday. They will release you Sunday. You will go to school during the week when you get into school. And that has to be done at the earliest possible time. You will attend school and complete your high school education. You will act responsibly. That's what all of these conditions are all about. Once again, if you fail, you're looking at life imprisonment. And all of those, every one of those conditions help you be a better person. Why you would work against that defies logic. But start acting, with intelligent thought, and school will help you. And also the probation office will help you. We have a 93% success rate, which is far higher than the national average. That's because we know what we're doing to help people fix their problems, except for the 1 in 14 who don't. All right. Anything else to add? Did you have any questions for me from parties?
None from the
Please
state.
see the probation officer
Starting weekends today or next week?
next weekend. That begins next Friday. Don't get in any trouble in the jail.
Yes, sir.
I find out on Mondays when people file up who are on my watch. And that would be a term of probation violation. Okay, do you understand? Oh. Please see the probation officer. Thank you. David, did you have anything else?
No, that's all I have.
Hey, David,
Yes, sir.
are you leaving now? You taking off? Going?
Well, I could stay here if I need to. Good.
Well, just one thing. This is, I guess, your last work day, realistically,
I think so.
as a public defender, as you're retiring again.
Well, I'll be happy to come over and finish anything I need to. I'll need to.
Help him. He'll be taking over. But we wish you the very best. And we were able to get something for you here. This is actually a collector's item that everybody worked hard to get because they don't make these anymore, and they are only VIP'd. But it's got the Jefferson County Bar Association Criminal Defense section, and they don't make those anymore. And it's a small token of our appreciation for all your efforts to help people, defendants. And it's been a long time. David and I were assistant district attorneys a while back together here. And he was the best basketball player in the city. Baylor graduate and great lawyer and long career. And you're going to continue working, I guess, and helping people.
Yes, sir.
That's good.
I'm completely retired yet.
Yeah. I would think Nancy would kind of keep you from doing that. She's going to keep an eye on it. But you're always welcome here, and let us know if there's anything you need. And we want you to stay on that rotating list as well for indigents who want to go to trial, because you're a great trial lawyer.
Thank you.
All right.
Can I direct this in the courtroom?
Sir?
Can I bring this to?
Anytime. In fact, you can fill it up and we're not going to check for what it is.
Thank you.
Thanks, David. Thank you. It's always been an honor working with you. I've got Leo covered. Actually, Joel, you're not helping on that one.
No,
You have Jeremy Dixon.
yes.
Let's look at Jeremy Dixon first. Did y'all get, David, you got all the cases transferred?
We'll have to do that September 1st.
Can we do that next week?
Yes.
All right.
Judge.
Okay.
September 1st, we can transfer everything over and get everything sent to Mr. Trump.
Okay.
Yeah.
Okay, Jeremy Gibson.
It's a motion for new trial.
You dropped the whole thing and you got away in it.
We now recall 23 CR 1222, the state of Texas versus Jeremy Dixon. And the defendant is present with Mr. Vasquez, his attorney. And there was a motion for new trial that had been filed earlier by the defense. And hold on. Okay, the court has signed an order denying the motion to for a new trial in this case. You've asked for a hearing. Go ahead. Did you want to add anything?
No, Your Honor, I stand by the motion. Just the appearance of impropriety. I realize it doesn't meet any of the criteria listed in the motion for a new trial.
All right. The court stands, nothing further. The court stands by the order that it rendered on August 25th. The motion for new trial is denied. What else? Anything else on that?
No,
Thank you. That is all. My motion is denied. It's denied.
The court just denied.
You'll get more of that.
Thank you.
Sean Neal, Washington. Sean Washington, please.
No, Judge, that was reset.
That was reset. Y'all got to help me here. They're going to look for him.
That was Rhonda. Process one day at a time.
Okay, John is on his way.
John is on his way to prepare Mr. Cover before he gets here.
Leo Cover. Leo Cover. Leo Cover.
See, sadly, start. I'm just teasing. You're on Zoom for Judge.
Come on up. And we're back. Leo, you got these two cases and
Yes.
we are going to move to trial. That's what you want still, right?
Yes.
Yes, sir. Okay. Y'all haven't been able, he's representing himself and you're going to continue to do that, correct? That's what you want. All right. When we've talked about it, I think ad nauseum, about the pros and cons. You've thought about it. You seem like a smart guy. You've decided this is what you want, and you know the pros and the cons. You still intend to represent yourself.
Sure.
Okay. We've got two cases here. One is a state jail felony of publishing or threatening to publish intimate matter, and the other is a state jail felony of theft. Now, let me ask, Mr. Cover has served almost 2 years in jail. 22, between 22 and 23 months. Is that the most he can get is a state jail felony?
Your Honor, what this priors is actually can be up to, he can be in.
Okay, help me out. I don't see the priors aren't.
They're not
this indictment.
They're not in this indictment, but he does have prior felony convictions.
Is he going to get notice? Is he going to get notice of that?
In the file.
Thank you, ma'am. What kind of, it's not in the indictment. Where is it in the file? Where have you received notice from them that they intend to present?
I got one that was from last year, but then it's been amended since, and I haven't seen it. At least that's what's on the computer.
I believe I filed before. I'm sorry. I believe that was when Mr. Kimmler was representing him. I believe it. But Your Honor, I believe I did file. I'll pull it up real quick. When Mr. Kimmler was representing him, I believe I filed the notice of intent to seek enhanced punishment.
Okay, is that the amended?
No.
One. That's what he needs the most updated.
Yes, sir.
Can you get a copy of course? Did you want? I don't know. I'll be checking so I can see what you're looking. I don't even know what it was. All I see is state jail felony.
Correct.
But if you have prior convictions and they give you notice,
that's for the punishment.
It could be the punishment could be up to second degree felony, depending upon what it states. All right, here's a first amended motion. All right. Notice. Here, give this to Mr. Fleischer. I handed this to you, Leo.
Mm-hmm.
All right, it states that you were finally convicted of burglary of a vehicle in 1980 in the 179th District Court of Harris County, Texas. I think that was a third degree felony back then.
Yes, correct, Your Honor.
It's not now, but if it is, then
I'm not even arguing any of the convictions.
I understand that, but then next is that you were finally convicted of illegal possession of controlled substance in 1980, and before in a different cause number. Then it states you were finally convicted of aggravated robbery out of Montgomery County in 83. You were also convicted of another aggravated robbery in 1987 out of Sabine County. And in 1993, convicted of retaliation out of Sabine County District Court. So, each of those could, if one or more are true, or two or more are true, then those could enhance your punishment from a state jail felony punishment to a third degree felony punishment. But then you've got those last two paragraphs that state that after those convictions were final and before you committed this new offense, you were finally convicted
And it would just bring it to a second degree, Your Honor, just their.
Well, what was the conviction?
If I'm mistaken.
What's the subsequent? Hold on, everybody. Let me talk.
Yes, sir.
When I speak, everybody stops so she can take down, because she can't take down everything if we're all talking at once. What is the most recent conviction after those others we've talked about? Is it the aggravated robbery in 96?
Yes.
Okay. And then also escape in 96, right? That's correct. That's what this is showing. Okay. So those two are in sequence of the prior three, the 5 prior convictions. And if all of this was true and you were convicted, then your punishment range then becomes second degree felony punishment range, up to 20 years in prison. Okay. But you got a copy of that?
I don't think that's correct.
They got to prove it as alleged.
I mean, it says.
I know, but it's not.
It's aggravated.
Yeah, but it's, this isn't a debate here. It's what they put that in to give you notice. They better prove it, or else it's not adequate.
First, I have to be found guilty.
Yeah.
And I don't think that's going to happen.
Okay. You want to represent yourself?
Yes,
okay.
I do.
And you've thought about it long and hard, and this is have you ever represented yourself before in a trial?
Yes, sir.
Okay. Well, you know that the judge expects you to know the rules of evidence and hold you to it, and the code of criminal procedure and the penal code. Okay. And these guys went to law school, and that's what they do for a living. So you can represent yourself, but it's always been for the most part, it's been difficult for defendants to represent themselves against people like this. But you understand that, and you wish to move forward. How many witnesses do you intend to call?
Your Honor, there's only, I believe, four or five at most.
When can we put this in for trial?
Judge, I have a special set on November the 4th.
Well,
3rd.
And Your Honor, we're trying to make sure Mr. Cover is allowed to go through all of his discovery on this, which I do have it tabbed out, and we're allowing him to see some of it, but there's a large volume of the electronic data on here that we're allowing him to go through. I think we're going to schedule it, I believe, for next week. We're going to schedule
Next week.
a day for him to come back and review it in the jury room back there again.
It's pages. It's going to take a minute.
Yeah, I know. Take as long as you need.
And my motions that I filed, I haven't had motion hearings.
Yeah, go over them. Which ones do you want to ask? What are you asking for relief for?
I'm asking because of the delay of trial, speedy trial. I've been trying to get a speedy trial. I haven't got here. I'd like to know about if the indictments. I don't even think I think I got a rubber stamp indictment. I don't think I haven't had a motion hearing. I haven't had discovery. I've been filing my motions. I haven't had any.
What motions are you asking for?
Nobody else is.
You did look at your motions. You asked me what motions. You're the ones that filed it. Get it before me. Come on. Yeah.
I want to hear the pro se motion for the writ habeas corpus. Writ habeas corpus.
What do you want to add? What do you want to add to that motion? What do you want to add other than what you put in the four corners?
Hear the motions heard, and I want to hear an order.
No. What additional evidence do you want to add to it, sir?
No, I don't need any.
Then it's overruled. I've looked at it. Unless you have something different than what you put in the four corners, it's overruled.
Okay.
But it's preserved for error. But it's a preserved error.
What about the motion for the question set aside the indictment?
That is denied.
Okay. Am I going to get a written order on any of this, or are you just going to deny every one of them?
We're putting the order into the record. And if you want a copy, we can make that later.
I have a copy of all of it.
Are you going to interrupt me, Leo? Come on.
I haven't got a copy of his amended
sir.
briefs. I haven't got a copies of nothing.
Sir, when the court speaks, you need to stop. You're going to get a fair opportunity to speak.
It's not always fair. You're denying everything I do.
We've done this once again.
How the hell is that fair?
When you shout over the court, she cannot do her job and and that's improper. She's got to take down everything. Leo, you may not like what's going on here, but please follow the rules. And if you have a right.
You're not. You just sit there and deny.
I've read, sir, I have read this whole file, sir. You don't know. Are you clairvoyant?
Yes, I am.
All right, that is all. We'll set it. We'll see you at trial. Thank you, Leo. You can't be calling people names and speaking over people. It's rude, Leo. You know that. All right. Next. Is Joe, what are you here for? What additional matters are you here for?
It's visiting, Your Honor. That's
You have anything else to do? You want to visit some people in jail, some of your clients or something, or?
Have a lonely life, Your Honor.
You thought about getting a dog or something? Like a pet?
He ran off.
Pet left you?
The cat ran off. The goldfish stayed.
But if the goldfish could have run off.
It's a start, Your Honor.
I mean, when is John supposed to get here?
That he's on his way, Judge.
So we got Jared Fowler on 3 cases, and then Matthew Graham on 3 cases. Is that it?
Cameron Smith.
Carla Culver.
Well, what about Carla Culver? I don't have Carla Culver.
This is a hearing on the bond issue on appeal that we had in chamber discussion, and we wanted to put everything on the record.
Where's I need that file.
There was a note that Ken had the file, so I don't know if he's here today. Let's see.
Who does?
Ken.
Because he was here. But that's all I saw with the note that he probably had a file.
Okay, thanks.
Just the assistance probably. It's just one of those. You didn't do, because it was just different. Right, this. No. There's Jonathan. I've dealt with him before.
You got Jared Fowler and Matthew Graham?
Yes, right.
And thank you for getting up here.
Yeah.
Who do we want first? We got plea hearings. So are those already done and ready? Or
no, the Fowler need to sign up, but the other one's an announcement, Your Honor. So we can take.
Do we need Graham out? I'm sorry.
So soft.
Yeah, we got Matthew Graham and Cameron Smith.
Yeah. Cameron Smith, sorry, I've been pled. It's just the sentencing. Fowler need to sign up, and then Graham, we just said.
Okay, Cameron Smith in first. Thanks. We'll just take that one out and let him get me.
And you're at this office as well. This is all I'm sitting in. This is him, that's all question. Even know if he actually has it, but.
I don't want to know. How are we getting? Where we saw even tonight calling. We have the file about him.
Yeah,
That's probably we forget. No, both of them, it's just fine, but I have one, but yeah, that's the judge. Seriously.
Yeah.
Okay. Be a chance to speak. Just ask me, so it's on one, I'll make it sure. Not necessary. I can't remove. So are you good? I'm gonna be flipped through the last 3 weeks. There's somebody, we're getting way off. I'll be there for a couple of weeks. Actually, even 3 weeks if you try. I had to cover 2 murder cases. It was one. Also. This, no, there's a moment. I'll just say this. Got to sign that up. 5 minutes. Thanks, back there.
Okay. Y'all are gonna have to refresh my memory on this.
Yes, sir. This is a case where we pled a while back.
Did he abscond? Before sentencing?
Yes and no. Okay. He absconded. He didn't come back for sentencing, but it wasn't his choice. He got arrested and was in Harris County Jail. So that's why he didn't show up for sentencing, is because he couldn't. He was incarcerated at the time.
What happened?
That case was eventually resolved. It was dismissed, pled to drop to a misdemeanor. He got credit for time served, and then released, and then it's over here now with us to finish this up. It's been resolved over there now, but that's why he was not available when we originally had our original sentence date.
Okay.
So like I said, yes, it was absconsion, but it wasn't voluntary.
It appears as though he entered his pleas in cause numbers 23 CR 2000, third degree felony of deadly conduct, discharge of a firearm, and 23 CR 2001, the second degree felony of aggravated assault with a deadly weapon. These occurring, it looked like, on or about the same date. And shooting at a vehicle and knowingly or recklessly causing bodily injury to another person. They have. That's okay. That's insurance. That's two options. Okay. So shot at a fire at a vehicle that was occupied, and somebody in the vehicle was injured.
That's correct, Your Honor.
Okay. And that's the second degree felony of aggravated assault, carved out 2 crimes out of 1 episode.
Yes, Your Honor. There was I apologize, Your Honor. I was just gonna get a court kind of breakdown of it if you would like. But
okay. The defendant entered these pleas of guilty to these offenses on December 9th, 2024. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? And are there any corrections or changes to it?
No,
State,
none of them state
or defense?
Same, Your Honor. We've reviewed it and there's no corrections.
Then without objection, it will be part of the record. The agreement is whatever sentence shall not exceed a cap of 7 years in each case.
Yes, sir.
So we're looking at two options, really.
Yes.
No less than 2, no more than 7 years confinement in prison for each case. Or deferred or unadjudicated probation. Regular probation, is it agreed upon, is not an option because a deadly weapon, namely a firearm, was used in the commission of these offenses.
That's
correct.
correct.
Okay. Go ahead.
And Your Honor, I do have a letter that my client has prepared for you if you want to admit it as evidence or have him read it later or wait.
Whatever you want to do.
Do you want to read it or you want to? Okay, we get that point. Hold on a second. We'll wait to get this one. Select me to go first or the state?
And again, you are Cameron Jace Smith. Mr. West is here representing you and the state's attorney is here. So, okay, go ahead.
Your Honor, we are going to be requesting the probation, the deferred probation, in the sense that this is my client. He doesn't have any prior convictions, felony convictions. This was an unfortunate incident. I'm not going to even justify that. It's unjustifiable, but it was a mistake he made, a horrible mistake he made. But I think he has been remorseful since then. He has a letter that he's written kind of talking about that. I would like to call him as a witness and have him explain some stuff to you. So you can
raise your right hand. You solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth. So help you God.
Yes, sir.
Lower your hand.
Thank you, Your Honor. Mr. Smith, go ahead and for now, you've written a letter to the court. Is that correct? Yes, sir. Go ahead and read it into the record so the court understands kind of your position. I think it's better than you just speaking. Go ahead.
While being incarcerated, I had time to think and reflect on my decisions and my choices. Something I've done to help myself, I'm not going to go this for making excuses for the way I'm doing my life. I can carry blame on this and that person, or this person, but ultimately, it starts with me and the people I surround myself with. I'm at a point in life where I'm becoming a man and I'm learning about myself every day. You know why? Your Honor, I want to give my sincere apologies to the court and the victim for my actions. I would like to ask the court to make a harmful decision when determining my eligibility for probation and take into account the positive momentum I have doing despite not having the proper guidance. All people need sometimes is one more chance to put the best foot forward and to go. Please allow me to show you and my family and myself that I can be a functioning member of society and not a holding thing.
Okay, and also you just told me something a moment ago when we were standing here, something that's happened since the last time in the court, which was just earlier this week. What's happened since earlier this week?
I just had a daughter 2 days ago.
Okay, so is this your first child or how many children do you have?
2 kids.
Okay, this is your second child? Okay. How old is your other child?
Mm.
And you've been in jail for how long right now?
Well, what's the date of birth of the child? What's the birthday of your child?
August 27, 2025.
His youngest one was just born 2 days ago.
August 27, 2025.
No, but he had another child.
Oh, what's the birthday of the other child? I'm sorry.
November 11, 2024.
Okay. All right. And you understand that doing the right thing is important for those kids, correct?
Yes, sir.
Okay. Setting an example for them is very important. Is that right?
Yes, sir.
Okay. And is it your hope to start living a good life if you get probation?
Yes,
doing the right thing.
Yes, sir.
Okay. Now let's talk about the thing over in Houston because I know that's an issue. You did not show up for our last sentencing date. Is that correct?
Yes, sir.
Okay. Where were you?
Harris County.
Okay. All right. Harris County Jail, correct?
Yes, sir.
Okay. You had some charges over there, right?
Yes, sir.
Those charges have since been resolved. Is that correct?
Yes, sir.
You ended up getting credit for time served misdemeanor. Is that correct?
Yes, sir.
Okay. And then they released you and you came straight from Harris County to Jefferson County?
Yes, sir.
Okay. So since being locked up in Harris County before the sentencing, you have been incarcerated the entire time.
Yes, sir.
Okay. So you didn't miss court because you didn't want to show up, right? Okay. It was because you were unavailable, correct?
Yes, sir.
Okay. And you're asking the court to grant you a chance on probation, is that right?
Yes, sir.
Okay. Do you think you can do probation?
Yes, sir.
Okay. You got any work lined up or something you can do, or what are you going to plan on doing?
Yes, sir.
Okay.
I'm ready to go back to work. I take care of my kids.
Okay. Go back to work. What were you doing before then?
I work in Home Depot.
Okay. And can you go back to Home Depot?
Yes.
Okay. Do you know if that job's still there, or you just think you can probably get that job?
I still get the job.
Okay. Okay. How much were you making at Home Depot?
$8 an hour.
Okay. All right. And you expect to go back making that same kind of pay?
Yes, sir.
Home Depot here or roughly where? In Houston, okay, all right. I'll give him in Houston. So you can satisfy the requirements of probation if you're given a chance.
Yes, sir.
Okay. Stay out of trouble.
Yes, sir.
Make your payments.
Yes, sir.
Do your community service.
So,
That's the way to try it.
Mr. Smith, on October 22nd, 2023, who were you there at that apartment complex with there, the Hamlet Park Apartments?
with my cousin,
And who's that?
Cameron Moon.
Okay. Were you also with an individual by the name of Victor Green?
No, sir.
And just prior, what kind of, did you have a gun on you that day?
Sure.
What kind of gun? Was it a handgun or a long gun? Did Cameron have a gun on him?
No, sir.
Yeah. Who was walking with you towards this black Mercedes just before the shooting there?
I don't remember their names. So, sure.
Did that individual have a gun?
Yes, sir.
So you're the only one who had a weapon there?
Yes, sir.
Well, hold on. How did you come to know that person who's unnamed, that you don't know, whose name you don't know, but yet you're involved in shooting with some people in the car, and you're with somebody and you don't even know their name? Who's that, and how did that happen?
It was just,
You have to speak up so she can hear.
It was me being with my cousin, and I was with one of his friends, but I don't like know his real name. Well, I just met him that day. So me just being with him, me being in the office for a long time.
Okay. Go ahead. So the other individual that's with you, were you ever walking towards this black Mercedes vehicle?
No, sir.
How did how did you start shooting?
Because it was the Mercedes pulled behind me and started shooting at us first.
I have no further questions, Your Honor.
Real quick, I just want to clear something up, Your Honor. I think that it's clear, but I want to make sure. This other individual that you don't know, it was a friend of your cousin's, correct? Okay, so you were there with your cousin.
Yes, sir.
Okay. So you just met this person that day.
Yes, sir.
Okay. Not a friend of yours, not a relative of yours, or you had no contact except for the fact that he was your friend of your cousin. All right. That's what it's. Nothing more.
Nothing further. No other question.
So, where'd you get your firearm that you were shooting at the car with? Think about it.
From Frank Houston.
Who? He's a friend of yours. You don't know his name?
His name is Josh Moore. Josh Moore.
Where does he live?
In Houston.
Look, I know 2 million people are in Houston. Where in Houston does he live?
Southwest Houston.
Okay, so why did you have a firearm with you? At 19, you're 19 years of age when this happened, right?
Yes, sir.
Then what are you doing carrying around a firearm shooting at cars? Is it something to do in Beaumont?
No, sir.
Oh.
I don't think it was a good decision either.
I looked at all the paperwork here, and we found all kind of guns where he was hiding: a rifle, handgun, shell casing. Who had the rifle? Y'all had a rifle. Who had that?
That's the when the Mercedes started shooting at me first. You know what I mean?
Your Honor, what the witnesses described in the Mercedes and a witness who was nearby described two individuals walking towards that black Mercedes with weapons out, which one of them was a handgun, which we believe was Mr. Smith, as well as the other individual had a long gun. Is that right?
No, sir.
Nobody had a long gun?
The only two people that had long guns, the two people that came out the Mercedes shooting at us.
I'm sorry, but you had a gun.
Yes, sir.
And Your Honor, the witnesses who were in the Mercedes said that they pulled near a dumpster turnaround there, which one of the individuals in there lived at those apartments, and they saw Mr. Smith as well as a Victor Green, who had formerly dated one of the individuals in the car, walking towards them with guns. The two males in the back of that black Mercedes jumped out with guns as well, which were long guns. And they said that I'm sorry, it was Faith Simon as well as the complainant here, Jayla Charlotte. They were in the vehicle along with a Daniel Harvey Jr. and a Joshua Slaughter. So the two females, Miss Charlotte, Miss Simon stated that both Joshua Slaughter and Daniel Harvey Jr., upon seeing these individuals walking towards them with guns, jumped out with their own guns. And they described the individuals walking towards them, started firing, and shortly after they returned fire. They were the ones who contacted the police. The other individuals that were there, it wasn't Mr. Smith nor Mr. Green who were involved in that. And they found police found Mr. Smith hiding there in the little fenced-in area of one of the apartments right there, and there was a handgun hidden in the I believe the barbecue pit right there, 9mm. There were also several apartments that were hit, Your Honor, with stray bullets. No one there in the apartment complex was injured, but there's also a nearby home that was struck with the bullets. So it was quite dangerous. Yes, Your Honor.
Okay. What are you asking for?
Your Honor, I believe
I see what the deal is.
Yes, sir.
What are you asking for? I would just say.
I believe the 7 years is appropriate. There was by going ahead and taking it upon itself to then start firing first and create this situation that could have killed or injured lots of people there at the apartment complex. Your Honor, I believe that warrants that kind of activity, and doing those things warrants every bit of the 7 years. They actually, took a step further rather than just having the gun. They went there and started firing and could have injured not only the individuals in the car more severely, they also everyone around, kids, people living there. Yes, Your Honor.
Okay. So I just want to get this clear. Why were you shooting at? What's your final answer here? Why were you shooting at God bless you, at the car?
No. Mm-hmm. I didn't shoot at the people who jumped out with the sword. What they saying, I don't want to put the blame on nobody else, because I know I'm in the wrong for being there, and I'm taking accountability of my actions.
No, you're charged with deadly conduct, right? That's discharging a firearm in each of these cases at people without good cause. Why were you firing the gun?
Because two people, I'm walking in the apartment.
Why did you shoot the gun?
And two people get out the car and get to shooting at me
first?
Yes, shooting me first.
Okay. We'll set this for trial. He just admitted he's acting in self-defense. He is not admitting culpability to this. We're going to put this in trial and try these cases. I don't accept the deal when you're looking at me and telling me that you're doing it in self-defense. That's not accepting responsibility. Here, it's set for trial. That deal is off. We'll let a jury decide each of those. All right. What else? Did you get, are you working on Fowler?
I got him to sign this stuff up.
All right. What else do we know? This. Well, that's when we talk yourself out of the deal.
I guess I'm burning out.
This doesn't have to. Yeah, claim a defense and say it was self-defense and then say you're responsible for a crime when you say one thing and then say another thing. You gotta stand by whatever you're gonna decide to do, but changing your mind and creating stories. I've got Jared Fowler and Matthew Graham.
I'm just wondering that Fowler right now.
Where's title of law? There we go. Todd, are you ready?
Yes, sir.
Come on up. Let's take care of this.
Ready for you?
Yes.
End of years, I see Jan.
Okay. We call 23 CR 1647, the state of Texas versus Carla Culver. And Mr. LeBlanc is present. The defendant has been found guilty of aggravated assault causing serious bodily injury and sentenced to, was it 8 years imprisonment by a jury. And the defense is requesting an appeal bond that in this case, and go ahead.
I'm sorry.
Mr. LeBlanc, this is your motion.
Yes.
Go ahead. You're the movement.
Well, I want to make sure the court takes judicial notice. There's a brief in the file. Came in yesterday.
Yeah, I'm reading it right now.
Okay. Judge, I would.
We'll summarize it.
I'm sorry.
Summarize it. Without looking at your notes.
Yes, Judge, it was, I'm sorry. It
No,
basically.
look at your notes.
sets out what we've discussed the past 3 weeks, two separate hearings that we've been here, is the court's ability to set an appeal bond. And
I think over 10 years 10 years or over, an appeal bond is generally not grantable. If it's under 10 years, I think an appeal bond can be considered by the court.
yes, Judge, if it's a misdemeanor, there are two persons entitled to a bond. If it's a
Less than
felony,
10 years.
that's less than 10 years.
And she was sentenced to 8 years.
Correct. And then she's can request one, and the court has the authority to set it. Depending, no matter the time, as long as it's before the appellate court has resolved the case, as long as it's done before then. That's the only time constraints that I've seen in the research shows. And I think that's reflected in the brief that's submitted to the court. It says it's a maybe abuse of discretion to not allow hearing, which I guess is what we're doing here. My understanding is that brief, the law speaks for it speaks for itself. What we need to be here for is setting reasonable conditions for, and that's what we're prepared to do, is to request the court enter the order that's already, I believe, already entered on the 8th, and set reasonable conditions for it to be released on bond.
But an appeal bond is grantable, but it's discretionary with the court. And there is no discretion with 10 years imprisonment or over that they don't get a
I don't think you bond 10 years ago.
All right. Here, the problem has always been in this case and in similar cases is that a deadly weapon was used in the commission of this offense, namely a motor vehicle. When a deadly weapon is used, the court's history has been not to grant appeal bonds because it's an aggravated offense. And the sentence is going to have to be, because a motor vehicle, a deadly weapon was used, then it affects her parole as well. She's going to have to serve 50% of that time before she's parolable. But an aggravated offense, when a deadly weapon is used, the general practices, I can't remember an exception to that, the court has not granted appeal bonds. Go ahead, but whatever, I want to listen.
And the court started out saying that the fact that it's aggravated and the deadly weapon use has always been the issue. Respectfully, that issue didn't come up till last week prior to the.
No, sir. No, not to interrupt you, since I wrote an article on this. And a deadly weapon is defined under the penal code as a firearm or anything that is capable of causing serious bodily injury or death. Here, it was alleged by the indictment that she intentionally, knowingly, or recklessly caused serious bodily injury. That's what the jury found. Thus, by law, it is defined, the item that was used is defined as a deadly weapon. It's not a firearm, but it meets the other definition by law. That's what makes it aggravating. And that's why it's going to be.
Judge, my statement is anyway, that became an issue last week because prior to it had to do with whether or not the court could.
Just 1 second. Go ahead.
Was whether or not the court could vet the bond.
Yes, sir.
That's what we originally came here for.
And I think I can. It's just, that's not been my practice when a deadly weapon is used in the commission of an offense when someone is found guilty of the offense.
I must assume that the court was aware of that when the court did set the bond on the 8th, that it was an aggravated. Yes, I believe the court's.
Yeah, I did.
Well informed of all of it.
But there wasn't a hearing and I was not participant in that before that bond was set, and we object. Because of the deadly.
That's why we're here. Redoing this because the state.
We're here because the state.
I'm sorry. Let me speak. Yeah. because the state called foul, and it wasn't appropriate for me to do that without him being here and being heard. Since it's a discretionary move, not mandatory. So here we are.
Judge, I've gotten a number of bonds set in drug court or any other court without the states. All I did was go and ask the court, was you consider an appeal of the bonds? And the court said yes and said it and asked me to file a motion. The state got a copy of that. I believe that we're here because the last two times the state, through their counsel, has asserted to the court that you do not have the jurisdiction or the authority to do this. So he said there's statutes and there's case law. I'm pretty sure it's on the record. There's case law. They haven't produced anything. There's a brief right there with case law stating that you have the authority. You have the authority to do what you already did on the 8th. You could do what you did. You signed that order. You could do it. You couldn't deny it without a hearing. And that's what the rule says. You can't deny our request without a hearing. Now, you asked me last week if I requested this hearing. Technically, I mean, if I have to have a hearing to set on, and then the hearing should be about setting reasonable bond conditions because she's I think she's well within the range of what the court would set appeal bond on in this particular case. She had flawless record of reporting. She had no problems on bond. Somebody's ready to bond her out. They were ready to bond her out 3 weeks ago, on the 8th, when she was brought over here. We're here because you were told you couldn't do it, and that's what I thought. And then last week you said you needed to speak with your staff. We submitted this brief, says you have the authority, and it does not exclude this as a 3G. It's not one of the listed offenses. Her appellate attorney Barlow wrote this, and basically he went through the whole thing as far as the court can set a bond as long as it's under 10 years, and this is not an offense that is not one that the court can. Aggravated assault is not on the list. Aggravated sexual assault and all those other ones that were 3G are on the list. So the court can do this. Now, if you say it's not your policy, that's a different story. But I don't know. I do believe if you look through this brief, if you were to I don't know if rescind your order or without due process, I think that it's certainly reviewable by the appellate court. You were within your authority to do what you did.
All right. Anything else you want to add on this?
Judge, only thing is that, and I understand we talked about the ex parte as far as that was not the issue that came up. Once I submitted the request, I e-filed it like the court asked me to. I did exactly what the court asked. Submit a request for the bond. I submitted it. They get a copy of it. They haven't, other than him just saying objection right here, I haven't seen an objection from them. I haven't seen a request for a hearing. I mean, I don't think that you have to have a hearing to set it. You have to have a hearing to deny it. That's my understanding of it. And I don't know if Barlow he submitted this. I think last week he said he could be here by Zoom, but and that's why he submitted this. So I would urge the court to review that brief.
Yeah, I don't disagree with the brief that it is something that is in my discretion and I can do or not do. But what this court did is, and the reason that bond was set the first time, we already had a discussion on that. We've already had a discussion with everybody.
I'm sorry.
And it was based, as you know, it was based upon your motion for new trial that was filed.
Yes,
and I had a discussion with you,
yes, sir,
and your attorney, and then the state. And I fully explained to y'all why that was done and why the court, after speaking with you, after reading the motion for new trial thoroughly, the court made its decision, changed its mind after reading that. And I'm not going to put on the record, but we can, but you know what I said.
Yes, sir.
And that's by the court's misinterpretation when I didn't read that motion for new trial thoroughly. Then I listed to you after, with everybody present in that room, what the discrepancies were, and why I relied on that, and before reading it thoroughly, because it appealed to me that this was something I ought to deal with quickly for this lady's freedom. And upon reading it, the long motion for new trial, and the brief of Mr. Barlow, we had a meeting, and I told you, I listed why I made that decision and how that decision was incorrect based upon not thoroughly reading that motion for new trial. And I'm not going to talk about it. It's not something we need to talk about here on this record, but everybody knows, because I met with everybody together after that. And the court has the discretion. Now, I'm going to listen to what y'all have to say. What's the state saying?
Judge, we do object. We've never agreed or never had this court set a bond since I've been in here the last 10 years. I'm working on my 11th year in this court. Have you ever set a bond, appeal bond, on affirmative finding of a deadly weapon case? It's just the safety of the public, the safety of the victim, and also the fact that we're not limited to just jurisdictional stuff. When we make an argument, we still have other arguments we can make once it comes up. But this has been the court's policy, and we've never set a bond, or you've never set a bond on any case that's had an affirmative finding since I've been here. It's just been the court's policy. Also, if we want to get into semantics, we can get into the fact that she did have a prior in 2012, a prior misdemeanor probation, which was revoked. And so she couldn't even follow those rules just on a simple misdemeanor probation. So we object to a bond being set. We think the jury was clear. They wanted her to go to prison. That's where she goes. It's for the safety of everyone involved.
Okay, go ahead.
Notions of fair play. She was bench warranted over here. You were in your authority to set the bond. You set the bond.
I did. Yes, I was. And I'm going to say again,
yeah,
we can detail it on the record, but you know why I did it. And I don't think you want me to put this on the record. I don't think anybody does. I don't think it's necessary for a public display of it, but there was good cause why that happened. And there was good cause why the court has changed its mind.
Well, Judge, I believe the court was mindful when it did it. And
I was mindful no, sir. I was mindful about what it had been in that motion for new trial that this court did not thoroughly read, because what I read on its face disturbed me, and I felt like it was necessary to deal with this lady in a bond quickly. And I did. I met so quickly, I didn't even get the state present. I met with you and the defense attorney.
Yes,
but then court shortly thereafter, after the court read the lengthy transcript of the case, then I told you what my conclusions were based upon the motion and what the transcript reflected. And that's when the court changed its mind, which I had the discretion to do. And then because it's a deadly weapon, and I would have felt that there were some errors in the case, then I would have continued to grant that were viable. I would have continued to set the bond, stand behind the bond. But after reading that motion and the briefing, it is I'm treating this lady like I do all others in the same circumstance. This court's tried almost 600 jury trials, and I've been reversed hardly ever. Because I'm sensitive about it. And that's why when I looked at that motion for new trial, I got everybody together to try to fix a problem that I felt like I can fix.
And Judge, if I may respond, I think that
McRae.
Jillian Ingenfield,
And-
Ninja.
And Linda,
$100.42.
$900.42. Okay. All right, folks. How are you intending on getting that paid?
It should be paid by the 5th.
By the
5th.
5th, you're saying?
Yes, sir.
Okay. And how much is your monthly rent? Are you going to be able to pay September also, or?
So September and August will be paid by the 5th.
Okay. Can that get paid before? Well, let me ask this. Can you get it paid by is that a paycheck that's coming in and putting stuff together to pay that? Is that what you're doing?
Yes, sir. I'm in between jobs. I was working at Jack Products, but they kept sending me home due to me being a temp. So I switched jobs. I currently work at FedEx, and I work at Burger King. Also, I'm just
okay.
working.
All right. I'm just the only reason I'm asking is if you can get it paid, if you're going to get August and September paid by the 5th, if you can get it paid before noon that day or pay it on the 4th, then this case will be likely be dismissed as long as you've paid everything.
By the 4th, I don't know for sure if I can do it by the.
Well, I know. All I'm saying is, all I'm indicating is if we can get it paid, it can be dismissed.
Yes, sir. Thank you.
Okay. So what I will do is I will adjourn this out September 5th, 2025 at 12 noon. All right. That's an in-person hearing, so you'll have to appear at the courthouse, okay?
And if I get it paid before, I don't have to come to court?
If you get everything paid off and make sure everything's paid off, you don't have to show up.
Yes, sir.
Mr. McRae, just be in contact with Sydney. She'll let you know if it's going to be dismissed.
Yes, sir.
All right,
Yes,
thank
ma'am.
you.
Okay. All right. Thank you, folks. Evergreen Apartments versus Matt Hilton.
Jillian Engen for plaintiff.
Okay, where?
Here.
Thought I heard. Oh, there he is. I got him.
I'm here.
I just had to pick you up on the screen. I got you, sir. All right. What is plaintiff's claim in this case?
I have a balance including court costs of $2,271.80.
All right.
And sir, how are you intending on getting that paid?
I have a job now. I was unemployed for about mid-May until beginning of August. I paid $450 like 2 days ago. And then since I was the 26th, I got the check on 14 days later is my next payday, which is something like August the 10th-ish, something like that. I have a calendar in front of me. I would be able to pay another $800 at least. I'm only getting like 25 hours of work right now. You had asked in the beginning if there are any reasons why pay hasn't been, or why rent hasn't been paid. I have a few. I went to the Southern Michigan Legal Services online and I read some stuff and I wrote stuff down. One of them.
So you're gonna get an attorney?
I mean, I would have to, I mean, if you're gonna make it a judgment, I would have to clearly, I mean, I'm not gonna be able to pay them if I don't have a job, but I mean, I'll be able to pay I don't know how much I'll have on that check, but so if you don't want to hear about that, my managers at TJ Maxx, where I had been working, were extremely pushy, and I'd lied about my wage and hours, was one of the reasons why I became unemployed. And then when I had
been I gotcha, but the thing is that you don't know how much you're going to be able to. You won't be able to pay anything before the 5th, correct?
The 5th of August. That's correct.
5th of September.
5th of September. I won't be able to pay then. That's correct.
Okay.
So here's what
I'm going to adjourn it out to September 5th, 2025 at 12 noon. That's an in-person hearing, so you'll have to appear at the courthouse. And you need to try to figure out something or call counsel and see if you can arrange some type of payment plan if the landlord will enter into that, okay?
All right.
All right, thank you. Court does call the case of Evergreen Apartments versus Patricia Tiani. Thanks.
Jillian Engen for plaintiff.
And Ahmad Tihani. Probably I'm mispronouncing that all over the place. Pardon? Neither are here. Tiani? No one's present. You may proceed.
Thank you, Your Honor. I have a balance. Rent retained possession is $1,304.15. Court costs are $214 for a total of $1,518.15. Plaintiffs requesting a default judgment for possession only with a writ to issue after 10 days.
Judgment to the plaintiff, that is by default for possession, redemption amount, any amount requested, writ issue 10 days. Evergreen Apartments versus Dustin Mickles and Antoinette Mickles.
Remembers those.
Jillian Engen for plaintiff.
Like Dustin's here.
Yes, I am, sir.
All right, very good. Pardon?
Say, how are you today?
I don't know. I think I'm doing okay. Thank you for asking. How are you doing?
I'm doing great, thank you.
All right. All right. What is plaintiff's claim in this case?
I have a balance including court costs of $3,413.38.
All right. And sir, how are you intending on getting that paid?
I just wanted to let it know that I would have never got behind if when I moved over here, we were supposed to get a 3-bedroom, and 2 days before we moved in, the 3-bedroom was not available anymore. And so I don't know if you remember, but I was trying to get my housing voucher back a few months ago.
I remember.
Yeah, I just had to give it up because they wouldn't cover a 2-bedroom, which I had to go into because I had a family, I had to move. So that's the only reason that I got behind.
Okay.
Because my voucher wouldn't cover a 2-bedroom. So I just had to give my voucher up on August 23rd. But yeah, my plan is to basically go into my 401k and take it all out so I can catch up on the rent.
Got it. Okay. So how long is that going to take you to do?
I have to pay the remaining balance of my loan. So it should be around like September 20th that I'll have it paid, because I have to wait like a 14-day grace period after I pay it off. And it's going to be paid off on the 3rd, and then I have to wait 14 days after that. So around the 20th or 22nd.
Okay, so here's what I'm going to do.
Okay.
I'm going to adjourn this out to September 5th, 2025 at 12 noon. That's an in-person hearing. You might want to contact the attorney's office for your landlord and see if you can arrange either a conditional order dismissal with that plan in place.
Okay.
Or something along those lines. Okay. Otherwise, we'll deal with it when you get here.
You said September 5th. What the day is that, sir?
That's a Friday.
Okay. Okay. Perfect. That'll work.
Okay.
All right. Thank you very much. Have a great day.
Thank you. Have a good weekend.
You too.
Evergreen Apartments versus Jermaine Magum?
Jillian Engen for plaintiff, Your Honor. We will be submitting a dismissal. I believe Mr. Mangum paid up today.
Got it. Okay. Case is dismissed. That is without prejudice.
Thank you.
Glencoe Hills versus Tierra Malcolm.
Jillian Engen for plaintiff.
Not checked.
Tierra Malcolm, they are not checked in. You may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent to retain possession is $1,654.11. Court costs are $171 for a total of $1,825.11. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ to issue in 10 days. Gulfside Lakes versus Alicia Sarr.
Jillian.
On all of these. Is he pleading to all three?
Yes, sir. Yes. So in concurrent.
Okay. You are Jared Michael Patterson, correct? And you were here with John West, your attorney, and the state's attorney. Does the defendant waive a formal reading of the indictments and the arraignments here? Can we proceed in summary?
Yes, sir, please.
In summary, these indictments allege. Are we just doing on paragraph 1?
Yes, sir.
On each one?
Yes, sir.
Yes, sir.
They're all second-degree felonies?
Yes, sir.
All right. Okay, this is one event. There were 3 victims.
Good job.
In summary, sir, these indictments similarly allege that on or about December 14th, 2024, in Jefferson County, Texas, you committed the second-degree felonies of aggravated assault. Hey, Todd, can y'all go on outside, please? Thank you. So we can take up these hearings. that you committed the second-degree felonies of aggravated assault with a deadly weapon in 570, assault on a peace officer in 571, and assault of another peace officer in 572. Do you understand what you're charged with in these cases?
So I was acting funky earlier too, Judge.
Yeah, these are second-degree felonies, which mean you face a term of not more than 20 years or less than 2 years in prison in each case, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
Agreements have been reached in your cases. Where you would be pleading guilty, sentenced, is it 6 to 6 years in prison on each case? Is that right?
Yes, sir.
If I follow until run concurrent.
That's correct. Yes,
If I follow these agreements, you have no right of appeal of your cases. Do you understand?
Yes, sir.
Show you what's marked as States Exhibit 1 in each of these cases. Did you discuss those with your attorney?
Yes, sir.
And did you understand all of this? And is everything true and correct here?
Sir.
States Exhibit 1 in each case is tendered into evidence.
No objection.
Without objection admitted. Among other things, this states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictments that were read to you, or you read them. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. And you were totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
States Exhibit 1 is part of the record in each case. A pre-sentence report's waived here?
Yes, please.
I will follow these agreements, if nothing further. And I'm going to find, sir, you were pleading guilty in each of these cases voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from States Exhibit 1 admitted here in each of these cases to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of these second-degree felonies. I am following these agreements. You are hereby sentenced to confinement in each of these cases, to confinement in the institutional divisions of the Texas Department of Criminal Justice to serve a term of 6 years on each case. And these sentences shall run concurrently with each other. Stand by, let me get all this done. You don't keep hitting, man. I mean, these things, it's like the pad doesn't respond.
Oh, we had the same problem back there that we're having. It's not supposed to be touchscreen, but you touch it with your hand, it does stuff. That's a different pad. They weren't back.
When the budget kicks in October, we're getting new pads, so we'll set.
Oh, really? Yeah.
Always gotta wait for the fiscal year.
Yep.
Budget. Yeah. Remember that extra money
or even prepared to give money.
Yeah.
Unless she's actively.
Well, he also knows It's a civil lawyer that ran towards the end of the year. All these people have all this money. They settled a bunch of car wrecks.
Yeah.
See, these,
Oh, yeah.
all right. It looks like in 25 CR 570, a deadly weapon, namely a screwdriver, was used in the commission of that offense, and there will be an affirmative finding made in that case, which will affect your parole capabilities. On that case, an affirmative finding that a deadly weapon, namely a screwdriver, was used in the commission of the offense. The other two, I don't see them being affirmative findings in those other two, 571 and 572. And again, your sentence 6 years imprisonment in each case will be currently. What has happened?
Yes, sir.
Thank you. Next is Matthew Graham, finally. You are Matthew Graham, and we are here on, let's see, it's setting for an announcement. What are we going to do on this?
Your Honor, I need to go over the discovery with him. This is, even though it's an announcement day, this is my first time to appear with him in court. So we as well about 4 weeks so I can go over a discovery. And me and Mr. Boyd have negotiated. We still need a little more time. Try to do this.
All right, please get a resetting. Thank you. Anything else? Well, we are in wonderful weekend, all of you. God bless the United States and the state of Texas and Jefferson.
Yes.
All right, there's my sub. All right, what is plaintiff's claim?
I have a balance including court costs of $1,799.17.
All right. And ma'am, how are you intending on getting that paid?
For assistance, but I plan on getting it paid by the 5th.
By the 5th?
Yes.
Okay. Can you, will you be paying your September rent also or no?
Yes, but it'll be in a partial payment.
Okay, so here's what I'm gonna do. I'll adjourn this to the 5th, 2025 at 12 noon. All right, so you think you can at least get the back balance and something else paid, right?
Yes. Yes.
Okay. So I'll indicate that in the file. I'll set it for the noon time on the 5th. That's an in-person hearing. You'll have to appear at the courthouse and then we'll figure out where we're gonna go with September if you get all that paid. Okay?
Okay.
All right.
Thank you.
Thank you. Thank you. Gulfside Lakes versus Dewan Wintermate.
Jillian Egan for plaintiff.
You said they're here.
He is, yeah, he's coming.
Oh, there he is. Hello. Hello, sir. All right. What is plaintiff's claim?
I have a balance including court costs of $1,155.22.
All right. Mr. Wintermaid, how are you going to get that paid?
I just got a new job at Myers full time, so I should be able to start making payments by next week. And I also filled out an SER.
Okay, if you filled out an SER, what I'll do is I'll adjourn this to the 5th, 2025 at 12 noon. You should probably get what payment you can in because your September rent's gonna click in. If you're doing an SER, there's a form that came with your packet. That's called the rental assistance form. You'll need to fill that out, put the tracking number on it, put all the information on it, including your tracking number, and submit that to the court by next Wednesday.
Okay,
Okay? All right. Thank you.
thank you.
Gulfside Lakes versus Michelle Goebel and Marlon Goebel.
Jillian Engen for plaintiff.
We don't have either.
Goebbels? No response. You may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent to retain possession is $2,862.11. Court costs are $214 for a total of $3,076.11. Plaintiff is requesting a default judgment for possession only with irritation after 10 days.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ issue 10 days. Hamilton Crossing 2 versus Tiffany Roots.
Jillian Engen for plaintiff.
Jesus.
Tiffany Roots?
Yes, I'm here. I'm sorry.
Okay.
My camera.
I'll need it. Pardon? Oh, there you go. Okay.
Yes. Hi, good morning.
Good morning. Okay. And what is plaintiff's claim?
Your Honor, I have a balance including court costs of $1,566.
This is gonna go much faster because now she has an assistant. All right. All right. And ma'am, how are you intending on getting this paid?
Okay, so I was on a temporary assignment at my job, and the assignment has ended, and I currently just picked up a new assignment yesterday. I will be making a payment on Friday in an amount of $600. I also put in an SER, and I have an appointment with Hawk September 8th and September 9th for the appointment with Hawk and the appointment with my worker. So that's the plan.
That's the plan. Okay. And you'll have September rent clicking in. If you applied for an SER, then you need to fill out the rental assistance form that came in your packet. Submit that to the court by next Wednesday. Okay?
Yeah.
I will adjourn this matter out to September 5th, 2025 at 12 noon. That's an in-person hearing. You'll need to be here at the courthouse.
Got it.
All right. Thank you.
Thank you.
Hamilton Crossing 1 versus December Smith.
Jillian Engen for plaintiff.
December Smith?
Yes, I'm here.
There she is. Okay. What is plaintiff's claim in this case?
Your Honor, I have a balance including court costs of $446.
$446. All right. Okay, Ms. Smith, how are you intending on getting that paid?
I'm confused because on my court paperwork, it only says 270.
And that's probably because it's paid. Let me take a look at what we have.
Your Honor, that's the balance before court costs.
Got it. Okay. So you got court costs on there that brought it up to the 446.
Okay, and that's another problem because I'm not working right now at the time. I've been applying for jobs. Everybody has the hire sign, but nobody is actually hiring. So I'm really not sure on when that can be paid. I can see if I can borrow it from my siblings.
Okay, let's do this. Let me put you out a week. How much is their monthly rent?
0 at the moment.
You're at 0, ma'am?
Yes.
Oh, okay. So let's do this. I'm going to adjourn this out to September 5th, 2025 at 12 noon. Okay, that's an in-person hearing. Come down to the court and we'll try to figure it out. See if you can somehow or another get yourself caught up. If you can, in terms of talking to your siblings to help you out a little bit, okay?
Okay.
All right. So put it out to that date at that time. I'm going to ask you this. Please tell me you were born in December.
I was born in August. I just had a birthday.
What? Okay. You were born in August and named December.
Yeah. I figured I was conceived in December.
Oh, okay. All right. Maybe I shouldn't be asking. Okay, thank you.
No, thank you.
Right. You take care.
You too.
Hamilton Crossing 2 versus Jessica Jackson.
Jillian Engen for plaintiff.
Get her.
Okay, yeah, she's
Oh,
I'm here.
Okay, hello, Miss Jackson. How are you?
I'm fine. How are you?
I'm okay. All right, what is plaintiff's claim in this case?
I have a balance including court costs of $373.
Yeah.
Okay. And Miss Jackson,
Yes.
how are you going to get that paid off?
I'll have it paid next week.
Okay, so you won't be able to pay it before the first of the month, right?
No.
So you'll have,
I just paid $425 yesterday.
Yesterday?
Yeah, that was my whole entire day.
Okay. Is that included in the balance you have, Miss Engen?
I see a payment of $500 on the 26th. Ms. Jackson, was that a different payment than the one you're talking about?
Yeah, that was the first payment I made. I paid $525 and then $425 yesterday.
Okay, Your Honor, that might clear the balance. So let me
Right.
just check with my client.
All right, Ms. Jackson, I'm going to pass your matter. Did you want me to adjourn it, Ms. Engen, or are you going to try to check with them?
I think so, Your Honor.
Adjourn
If you
it
could
out?
Adjourn it, please.
Okay, so here's what I'll do, Ms. Jackson, is I'll adjourn this out. And what she's indicating is that if your balance is clear and you cleared out August, which it sounds like you have, and actually may have a little bit of a credit going in.
Yeah, that's what they told me yesterday. I had
September. Okay. Then the case would be dismissed. But I'll adjourn it out to September 5th, 2025 at 12 noon. Okay?
Okay.
All right. Thank you. You guys have a great holiday.
You too. Thank you. Papa.
That's it. Okay. Got it. All right. Glencoe Hills versus Tierra Malcolm.
Jillian Engen for plaintiff.
I had called this case. I'm recalling it because
I was on the phone and I guess I couldn't click fast enough and you kept moving. So anyway.
she's here and she's blaming me.
I'm not.
Right?
I promise.
It's okay.
No comment, Your Honor.
People blame me for a lot of stuff. Okay, so I won't issue the default in this case. Miss Malcolm, you owe $1,825.11. That's including court costs.
Yes, sir. Thank you. I'll pay. I do have, first I need to say, I have a intake with Autumn.
With Hawk?
With Hawk on the 16th
of
September.
Okay.
But however, I will be able to pay $500 on this coming week.
So you'll be able to pay $500?
Yep, $500 towards that.
Sometime before the 4th. Okay. So
And then I know I won't get another check for 2 weeks after next week.
Right.
So I will be able to have my whole balance paid off before the end of September, but I do know September rent will fall in now.
right, it will come in. So here's what I'm going to do. Get the 500 in. I'm going to adjourn this out to September 5th, 2025 at 12 noon. Okay, it's in person and you know how to get here.
Yes.
Right? Okay, so.
I was trying to break that door down. I told, officer,
whoa.
Yes.
Break the door down?
Yeah, I was trying to get in just to get to you, not to be mean, just to get to you, to let you know I'm here. I need my place.
No, it's okay, Miss Malcolm, but you start
I was like pulling the.
I know, but if you start breaking stuff, that's a whole.
Oh, I'm in trouble.
You come up in here trying to do the right thing and you're gonna catch a case.
I don't want that.
All right.
I don't want that.
Okay, so here's what we'll do. Like I said, get the 500. We'll see you next week.
God bless you. Yeah.
And then we'll try to see what can be worked out.
Thank you.
You take care. Have a great holiday.
You have an awesome holiday. You too. I love watching you guys. Just not being here.
Okay, thank you.
Same. No.
Wow.
Mommy.
Where was the attack on Cedric? I don't know. I didn't do anything. Strong Future Homes versus Alicia Davison.
Jillian Engen for plaintiff.
Alicia Davison, not checked in. You may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent to retain possession is $891. Court costs are $176 for a total of $1,067. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days.
Judgment to the plaintiff. That's by default for possession. Redemption amount, any amount requested with the writ issued 10 days. Baker Street Properties versus Lauren Devine. Evergreen versus Mohammed Al Matalo. Evergreen versus Kenyatta Mitchell. Gulfside Lakes versus Shante Galloway. Those matters are dismissed on plaintiff's motion without prejudice. I think I have this. Are these hers?
No.
They are not. Okay. All right. I think that's it.
Thank you, Your Honor.
All right. Thanks for helping your mom. She
She's a good
couldn't have
helper.
done it without you.
Got lots to do.
All right.
Thank you.
All right. Take care.
Bye.
Oh, wait,
Your
your
Properties versus John Zizer.
perfect. Here we go.
Zizer.
How are you today, sir?
Good morning. Your name?
Good morning. My name is John Zizar.
Okay.
Good morning.
All right.
On behalf of plaintiff.
Okay. And what is plaintiff's claim in this case?
There's a balance owing at this time of $1,391, including court costs.
And sir, how are you intending on getting that paid?
Well, sir, I am a tipped employee. I've been calling off of work a lot due to the fact that my brother, I just became guardian of my brother, my older brother, Ernest, and he was in an accident a few months prior, and I've been kind of focusing on trying to get my brother together with housing and whatnot. I've been just kind of set me back a little bit, but now that I got him situated, I got him in housing, and he's in a better place right now out of the hospital. I'm just, like I said, I'm a tipped employee. I'm just going to work and work and work until I get this paid off. I have $400 now I can pay tonight. I'm going to get
how much?
I have $400 right now. I'm going to go to work tonight and probably get another $200. But right now I'm only being scheduled Wednesday, Thursday, Friday, and Sunday, trying to pick up as much as I can. But I can assure that
here's what I'm going to do. I'm going to adjourn this out to the September 5th, 2025. What time?
1 p.m.
At 1 p.m. That's an in-person hearing. What I might suggest that you do is pay the $400. September is obviously going to click in. And then on your paperwork, call Mr. Fantero's office and see if you guys can work something out on this. Okay?
Sounds good.
All right. Thank you. Have a great holiday.
Have a great weekend.
Court does call the case of Sandy McFiddish versus David Robbs.
Good morning, Your Honor. David Fantero on behalf of the plaintiff.
David.
Good morning, Your Honor.
Good morning, sir. Where's he? Got it. Okay. All right. And what is plaintiff's claim?
The total balance, including court costs, is $1,696.98.
Ross, how are you intending on getting that paid?
I've paid rent every month. And I paid rent on this last month on the 5th. And the month before that on the 3rd, and the month before that on the 2nd. There's these extra charges that are been brought up for a gas bill, which I've never had to pay the entire 4 to 5 years I've been living there. So I asked them if they could show me and I could set up a plan to pay that off, which I talked to them and they said yes. And to show me the actual DET gas bill, because like I said, I've never had to pay this before, and they haven't came up with that yet. But I've been paying rent every month on time.
Your Honor, I will confirm that he's been paying his rent, but the balance is, the majority is DTE and gas bills. And it's my understanding that they did make a payment arrangement where they were going to allow him to pay $100 over and above his rent towards the balance. And he said he couldn't afford the extra $100.
And yeah, I said I could afford it, and I did start paying it. But every time after the 5th, you guys charge me a $75 late fee. So that extra money has been going to that because it's all on the same payment platform.
So you were
It's
paying the 100, but only getting 75.
Yeah, they were only getting 25 because they were charging me a $75.
Yeah, I don't think he was paying. Sorry.
I have the records for it.
Okay, let's do this. I'm going to adjourn this out to September 5th, 2025 at 1 p.m. That's an in-person hearing. Come in, bring your paperwork. Let's see if we can work something out on this, okay?
Sounds good. Thank you.
All right, thank you. Walkabout Creek Apartments versus Anastasia West.
Good morning, Your Honor. David Fanter on behalf of the plaintiffs.
And I do see the name.
Yes.
Anastasia West, you need to unmute and turn on your camera. Oh, there she is.
Hi.
Hello,
Sorry.
how are you?
I was trying to figure it out. I got it.
You did. All right. Mr. Pantera, what is the claim in this case?
The total balance owing, including court costs, is $1,737.
Give me that again, please. 1,000.
1737.
Got it. All right, Ms. West, how are you intending on getting that paid?
Right now, as of today, it's 737. I paid 1,000 today.
You did? Okay.
Yeah, I did. I sure did. And prior to now, I moved to Walkabout Creek, because my daughter was being bullied. So I left my last place without, having kind of the infrastructure in place for a move, but it was 100% necessary. My daughter was injured from a school bullying incident. Upon moving here, my mom came to help me, and then she suffered a stroke. So she was in Chelsea Hospital for about a week and a half, which kind of put a lot of financial strain on me. Ever since then, I've kind of been playing catch up between paying for her medical costs and keeping up with the rent. But it's again, where there's a will, there's a way. By September 12th, I'm gonna be caught up on not only August, but September too, because I've effectively caught up on all my mom's medical bills from then. So I'm not anticipating any issues in the future.
Okay, all right.
Let me knock on wood, though.
Okay, all right. Okay, here's what we'll do. I'm gonna adjourn this out 1 week to the 5th, 2025 at 1 p.m. Okay, that's an in-person hearing. Come in and then let's see how we can work this out. If you're gonna have it paid potentially by the 12th, then maybe something can be done on this if that's a plan. All right?
Yes, sounds good.
All righty. Thank you, ma'am. You have a good weekend.
Thank you. Thank you for coming to work today.
All right, thank you. I kind of have to. All right, you have a good one.
You too.
Danny Noonan versus Sarah Legistrin. Mrs. Haverkamp versus Demetrius Graham. And Sandy McFiddish versus Leo de Guzman. Those matters are dismissed on plaintiff's motion without prejudice.
Thank you, Your Honor. We'll see you at noon.
Yes, sir.
Have a good couple hours till then.
Arbor Woods versus Shakori Davis.
Rachel Dornbush, Palace Law on behalf of the plaintiff.
Shakori Davis. Oh, she's here. She's trying
Good
to
morning,
unmute.
Judge.
There.
Yeah, I'm trying
Good morning. All right. What is plaintiff's claim in this case?
With costs, Your Honor, $3,543.41.
All right. Ms. Davis, how are you intending on getting that paid?
Can she repeat the balance?
3,000. Oh, go ahead,
Go
Judge.
ahead. That's it.
$3,543.41.
Okay.
Okay. And Ms. Davis, how are you intending on getting that paid?
I have about 3,000. I knew about this already, but I was waiting to see what the court fees would have, what it would go up to. So, hopefully by the 5th, when you adjourn it, it could be dismissed, and then I could talk to them about September.
Okay, hold on.
I'll give them what I have today, though.
Pardon?
I'll give what I have today.
How much do you have?
I have about 3,000.
All right.
Close
Here's
to
what
it, at least like
we're gonna do.
2,800, Judge. At least right there with the 3,000. I should have 3,000.
So 28 to 3. Okay, so
yeah.
Here's what I want. Here's what I want you to do. Pay that to the landlord. Okay.
Yep.
And get that paid today if you can. And then what I'll do is I'll adjourn this out to September 5th, 2025 at 3 p.m. That's an in-person hearing. And then what we'll do is we'll attempt to try to figure out what we're going to do with September and the balance left over.
Okay.
All right.
All righty. Sounds good. On Friday at 3 p.m. in person.
Yes, ma'am.
Okay. Thank you.
Thank you.
Bye-bye.
Arbor Woods versus Ashley Irwin. Ashley Irwin, not checked in. If you'd like to proceed, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do. For the record, Rachel Dornbush, Palace Law on behalf of the plaintiff. Your Honor, there's rent to retain of $2,421.74. Costs are $186 for a total due of $2,607.74.
All right. Judgment to the plaintiff by default for possession, redemption amount, any amount requested with the writ issue in 10 days. Arbor Woods versus Runisha Yarborough. So she's here.
Yes.
Good morning. Right. Good morning, Ms. Yarborough. All right, what is plaintiff's claim?
With costs, Your Honor, is $1,659.48.
All right. And Ms. Yarborough, how are you intending on getting that paid?
I made a payment on Wednesday for August and September rent, and I should have a credit of $80 on my account.
Okay, so you think you paid everything off?
Yep.
Okay, the attorney may not have that yet. So here's what I'm gonna do. Oh, go ahead, I'm sorry.
I was gonna say, if we want to just adjourn it for the week.
Yes.
Once I verify, I can submit a dismissal.
Okay. So I'm going to adjourn it out September 5th, 2025 at 3 p.m. And ma'am, if what you do is, if everything's paid off, I don't really need to see you, but I'm going to set that date. If for whatever reason there's some hiccup, I'll need to see you in person.
Okay, sounds good.
All righty. You take care. Have a great holiday.
You too. Thank you.
Thank you. Arbor Woods versus Barshawn Zimmerman. Zimmerman. Okay, there he is. You'll need to unmute, sir. Thank you.
Can you hear me?
Yes, we can hear you, sir.
Okay.
All right. What is plaintiff's claim?
With costs, Your Honor, $1,139.03.
All right. And sir, how are you intending on getting that paid?
I actually was curious about just rental assistance. I'm familiar with the process.
Okay. So which part of the rental assistance?
Help with rental.
No, I know. Okay. So are you gonna try to do an SER?
Yes.
All right. Did you talk to Hawk?
No.
All right. Why don't we do this? I'm gonna do a couple things here. I'll adjourn this out September 5th, 2025 at 3 p.m. Okay. And then it sounds like you're not familiar with the process of everything. So,
right.
Amy, are you here? I know she's here.
Good morning, Your Honor. I am.
All right. So, sir, what I'm going to do is we're going to put you into a breakout room with Amy, okay? And explain what things are out there. There's a form that you're going to need to fill out called a rental assistance form. I'll need to have that to the court by next Wednesday if you're going to do an SCR or request any other type of assistance. Okay.
Thank you, sir.
All right. So I'll do that. And then that on the 5th, that's an in-person hearing, sir. So you'll need to be here at the court. Okay.
You said on the 5th at 3 o'clock?
Yes, sir.
And the 5th is a Friday, correct?
Yes, sir. Yes, sir.
Thank you, sir.
All right. Thank you. You hold on the line and we're going to put you into a breakout room so that you can speak with Amy. And Amy, good morning, if I didn't say so.
Good morning, Your Honor. Good to see you.
Good seeing you. All right. Go ahead. They're going. Okay. Court calls the case of Barbara Woods versus Leticia Johnson and Adrian Johnson. And they're here. Okay. Hello, Miss Johnson. How are you?
Good. How are you?
I think I'm okay. All right. Oh, there's Adrian. All right. Yeah, you knew he'd be the one late coming in. All right. No, I'm just messing with it. All right. And Ms. Dornbush, what is the claim in this case?
Now with costs, Your Honor, $3,691.12.
All right. Folks, how are you intending on getting this paid?
Can you hear me?
Yes, I can hear you, sir.
Okay. I'm about to say we had already put like 1,200 on it, but I think one of them just posted yesterday, and then my wife just put 500 on it.
I'm sorry.
Yesterday as well.
Yeah, my wife put 500 on it yesterday, and then I had already paid 700. But it just posted yesterday.
Okay. So do you show recent $1,200, Ms. Dornbush, or no?
I don't. I have to verify those payments with my client. So it sounds like they put a total of 1,700 towards the almost 3,700.
1,200. The 7 and 5.
Another 5.
Is that no? I think what it was is he was saying 1,200. I think
altogether.
It's all together.
Oh, okay.
Is what I think he was saying.
Yes.
I think if we let Miss Johnson talk, we'd all understand. I think.
Yeah, that's probably better.
I think he's confusing all of us. Anyway, so what I'll do is I'll adjourn this to. Well, let me ask you this, folks. How are you intending on getting the rest of this paid? Because September is going to click in.
I'm filling out another SER. We had to do it before, but the proper proofs were not there. And then also, we wanted to see maybe about talking with the office as well, too, because there is like some damage to the ceiling that we were trying to have fixed as well. We're not like withholding or anything. We had like car issues and we had to get things fixed. But so that's why we're
But the damage has been there for like significant amount of months. It stopped us from using our bathroom.
Okay, so here's what I'm going to do. If you want to get an attorney or you want to claim that there are some damages to the premises, then I'm going to give you a week to get to do that. Also, if you're filling out an SER, there's a rental assistance form that came in your packet. That needs to be filled out and needs to be submitted to the court by next Wednesday with the tracking number. And I think okay, there's Ms. Johnson, she's back. All right. And then I'll adjourn this out to September 5th, 2025 at 3 p.m.
Okay.
At 3 p.m. That is an in-person hearing.
Okay, can I just ask one question? Should we submit okay, because the problems is wrong with the place. Should we submit the pictures as well? We got pictures all the way back.
Well, you should submit an answer to the court or something to the court showing me what the problems are.
Okay. I can submit that by next Wednesday as well.
That would be great if you could, but you also need to send a copy to the attorneys.
Okay.
Okay. So whatever you're going to submit to the court, you've got to send to the attorneys. Their address is on the paperwork that you received.
Okay.
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 All right. Thank you. Barbara Woods versus Anthony Faber Jr. and Jennifer Faber. Not here. I do not have them. You have been sworn. You may proceed.
Your Honor, actually, in this case, the total that's currently due was $262. Rather than taking a judgment for that amount, I would propose adjourning it for a week. I can see if my client can reach out to them about getting that paid up.
Okay. Very good. I'll adjourn it to the 5th, 2025 at 3 p.m. Okay,
Thank you.
Thank you. Northfield Estates versus Bruce Androsian. Bruce Androsian, not here. You may proceed.
Thank you, Your Honor. There's rent to retain of $5,071.31. Cost of $213 for a total due of $5,284.31. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession. Redemption amount in the amount requested with the writ to issue in 10 days. Northfield Estates versus Rose. Is it Fuljohn? They have not checked in. You may proceed.
Thank you, Your Honor. There's rent to retain of $2,256.31. Cost of $213 for a total due of $2,469.31. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue in 10 days. Northfield Estates versus Brittany Harvey. Brittany Harvey, not checked in. You may proceed.
Thank you, Your Honor. There is rent to retain of $1,728.31. Cost of $213 for a total due of $1,941.31.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue in 10 days. Northfield Estates versus Jeffrey Costco.
I think he's here, Your Honor.
Yes, he is. Okay, you'll need to unmute, sir. And
can you hear me now, sir?
Yes, we can. All right. What is plaintiff's claim?
With costs, Your Honor, $2,902.32.
All right. And sir, how are you intending on getting that paid?
I would like to pay $1,500 every 2 weeks until it's current.
Okay, well, let me ask you this. You'll have to work that out with the landlord or the attorney, but because you've got September rent coming up.
Correct.
All right, so when are you going to pay the $1,500?
Not this upcoming Friday, 2 weeks from then. Or so, 2 weeks from today is what I'm looking at.
The 12th?
Sure.
Well, if that's the date, then here's what I'll do. You'll need to see if you can work something out with the landlord regarding that. I'll give you a week to try to do that.
Okay.
Or to come up with some funds, but I'll adjourn this out to September 5th, 2025, 3 p.m. Is that right?
Yeah.
At 3 p.m. That's an in-person hearing. So talk to the landlord or talk to the attorney's office and see if they'll work it out with you. All right.
Yes,
otherwise, I'll need I'll need to see you on next Friday. Okay?
Copy that.
Okay, thank you.
Thank you, sir. Have a great weekend.
You too. Northfield Estates versus Chris Woody. Chris Woody. Oh,
Hello,
hello. You are whom?
Jacqueline Papazian, his wife.
Okay, all right. Well, you're not named on here. Are you on the lease?
I believe I am.
No, Your Honor, Miss Andrea Clay, a representative from the property, is signed into Zoom. I'm going to ask Andrea to clarify if Ms. Papazian is an approved occupant.
Miss Clay? Probably looking.
Yes, she is, Your Honor.
Oh, she typed it in. Yes, she is.
Yep.
All right. All right, so what's owing on this?
Your Honor, they actually just made a payment, so the total due with court costs is $885.88.
$885.88. Okay, and ma'am?
Yes.
How are you guys intending on getting that paid?
I know my husband gets a paycheck on Friday, so a week from today, which would obviously cover that, but it's getting it to them in time before the court date. We also applied for a hardship for his 401, which has been weird because they had to approve our account for a 6 cents balance, and then he's got to call them again today. So we are hoping to have that before the 5th, if not on the 5th.
Okay,
And
if you
that-
have that on the 5th, what about September?
We're hoping, because I think like the whole balance with September included would be like 1,500. We're hoping to do it all is what we're hoping for.
Gotcha. Okay,
If-
that's what you're attempting to try to do.
Yeah,
Okay.
at the least, I mean, then September would be the following Friday when his next paycheck goes in, and then we just accept those late fees if Andrea approves that.
Okay, I got what you're saying. So here's what I'm gonna do. I'm gonna adjourn it out to the 5th, 2025 at 3 p.m. That's an in-person hearing. If get paid in what you can, if you get everything paid off, but yeah, good luck with the 401k getting everything done before then, but that's okay.
Such a
If
nightmare.
it's not done, then we'll try to figure out what we're gonna do with it, okay?
Okay, perfect. I appreciate you very much.
All right, take care. Have a good holiday.
You too. Thank you, sir.
Court calls the case Whitaker Oaks versus David Petrowski. And Vicky Pitt. Petrowski, Pitt, no one's here. You may proceed.
Thank you, Your Honor. There's rent to retain of $2,978.14. Costs of $240 for a total due of $3,218.14. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff, that's by default for possession, redemption amount in the amount requested with the writ issue in 10 days. I think that's all I have for you.
That is correct, Your Honor. And
All right, will we see you this afternoon or no?
Miss Matson this afternoon, Your Honor.
All right, very good. Then you have a great holiday weekend.
Thank
you. I trust you are doing well.
We are doing well, Your Honor. You'll probably have availability to see me through the end of September, and then starting in early October, I will probably be out for potentially the rest of the year, but that is all TBD. So.
Oh, yes, understood. All right. Well, we will be blessed if we have you through September. So we'll look forward to that.
It'll be fun.
All right.
Hopefully we make it through the end of September. That is the goal.
Okay. All right. You take care.
Thank you, Judge. You too. Bye.
Court stands in recess.
Issues, which is frightening to me because you're the same age as me. But Gary, can you hear me?
I can, yes.
Mary, can you hear me?
Yes. My problem is vision.
All right. Well, if you need hearing assistance, we have it available. Ms. McPherson, can you hear me?
Yes.
We've got a lot going on here. Good morning, Meg.
Morning, Judge.
I was calling your name before you logged in. I startled you and Rick Kupferschmidt in the rain on Tuesday. That gave me a big smile. He jumped about a foot when I honked the horn at him.
We did not realize that was you. And then I was like, oh, I should have been paying attention, but obviously we were rushing to.
It's like, get out of my way. No, I was on my way out of town and our guests saw you and I guess they got to see you up there as well. Ms. Kirkland, P2, who am I speaking with?
Your Honor, this is Pam Kirkland from the state of Michigan, Adult Protective Services.
In which case are you here on?
Miss McPherson.
All right.
Colleen.
And are you here as well? What's your name?
I'm Tony Laughlin. I'm with the Area Agency on Aging.
Yeah, we've met before.
Victim specialist.
How do you spell your last name?
Laughlin, it's Laughlin.
All right. You helped me on that frozen apartment case and some other issues, Miss Price and some others. So, all right, thank you for being here. All right, let me call a case. We're on the record. It starts at 9:10. We're a little early, but it appears that all of our players are here. The title of this case is Gary and Mary McLean versus Colleen McPherson. And you're Gary McLean.
Yes.
And you're Mary McLean.
Yes.
And you're Colleen McPherson.
Yes.
Also present is Pam Kirkland from Adult Protective Services and Tori Laughlin from Commission on Aging. And Megan Bauer from Legal Aid. Also present is Douglas Kuhlman, is this Fabius Township?
Yes, yes, it is, Your Honor.
Zoning administrator. So there's more here than meets the eye. What the case is presented here as is a termination of tenancy. This is a property at 15271 Mooney Lake Road in Three Rivers. It's in Fabius Township. I'm familiar with this property. There were some small claims cases and other things out there. The McLeans have a small farm there. They want you to move, Miss McPherson. This is called a termination of tenancy action. You are a defendant in a landlord-tenant case regarding termination of your tenancy. And as such, you have certain rights as a defendant in a landlord-tenant case. First of all, you have the right to hire an attorney. If you cannot afford an attorney, one may be available from Legal Aid. And one of the faces on the screen is Megan Bauer from Legal Aid of Kalamazoo. So she's monitoring what's going on here. And if need be, I can put you in a place where you can talk privately with her. We've also got the zoning administrator from the township, and we've got Adult Protective Services and Commission on Aging. You have a right to have the case heard here in St. Joseph County where the property is located. I don't know why I have to tell everybody that because it's never been an issue even once, but I am required to advise people of that. You have a right to demand a jury trial. If you want a jury trial, you must tell the court at this first appearance or file the demand in writing within 5 days using the appropriate court form and be prepared to pay the $50 jury demand fee unless the judge waives the fee for your inability to pay it. If both parties are interested in mediation, the court can help set that up and make a referral to the Citizens Mediation Authority. You may be able to reach an agreement with the landlord that means the case would get dismissed. the court must provide you with that information to prepare a conditional order of dismissal, or perhaps one of the attorneys would prepare it if there is one. All right, Ms. McLean, at this point, you're all living in the same house at Mooney Lake Road, is that
That is
correct?
not correct.
All right. Is this the apartment in the barn?
Yes, and when we got our permits in 92 from Mr. Niken, we permitted a farm dwelling inside the barn because we intended on doing livestock and needing agricultural help. So that was built in 93, and I have the original building permits with me.
All right. Is there a lease?
No.
Does she pay rent?
She did a little bit. Mr. Kuhlman pointed out to me that my kindness gets me in trouble every time because he's known me a little bit through this.
It's called no good deed goes unpunished.
His exact words.
I think he heard that from me.
Yeah.
All right. So at this point, how long has she been there?
In January, she appeared with not a dollar to her name and her belongings in a snowstorm, and I allowed her to move in with nothing.
Is she related to you?
No.
How do you know her?
I had known her through Facebook for 2 or 3 years. She'd come out a couple of times and visited, and when I had different things open, and then we visited just prior to that because my goat birthing season was coming on, and my Mr. McLean loves to be able to go away for a little while in the winter, and some of my farm help is to help with whatever's going on. And oh, she'd be so wonderful help. She'd help me with the birthing of the goats and this and that and the other, and seemed like a very nice woman. She only had one pet, and
all right. Well, we don't need to get into this issue right now, but let me ask Mr. Kuhlman, is this place lawful for habitation?
No, Your Honor, it isn't. And that's the whole problem. Back in May 30th of 2017, an administrative search warrant was executed on this same building, actually the entire property. Back in May of 2017, this area was placarded as unsafe for human habitation. No enforcement action was taken at that time because Ms. McLean was cooperating. I would just indicate for the courts that I do have 2 open cases coming up on September 23rd. Where on this occasion I did cite Mrs. McLean for 2 violations of township ordinances.
All right, well, let's talk about that. Ms. McPherson, they want you to move. You don't have a lease, you're not paying any rent, and the township says you're not supposed to be living in there. Have you made any provision to try to move?
I've been trying to move out of there since February. I paid rent up until June 15th.
How much was the rent?
$1,000 a month. And I have.
Stop. So you paid $1,000 for January, February, March, April, May, and June?
Yes.
You disagree with that?
absolutely did not pay that.
All right, well.
I did set the rent at $1,000 in February when I could see she would be of no use to the farm and high so that possibly she might find a place to live. And she was amicable in the beginning.
All right, well, obviously, at some point, you're gonna have to move out of there. So let's hear from Ms. Kirkland of Adult PS. Is Adult PS attempting to help her find a place to live?
We are, Your Honor, and that's why Tony Laughlin, she's with Area on Aging, victim advocate. She is assisting me in helping Colleen find a place. Colleen has been looking locally and as far as Kalamazoo as well.
Ms. Laughlin, have you had any success with that?
We do have potentially an apartment, but it is going to take a little bit of time.
All right. The law requires that I continue this matter for at least 7 days, which would take us to next Friday. Meg, this doesn't appear to be much of a legal defense. She's not supposed to be living there. They need to get her out of there. We're not asking for money damages at this time. And she's got 2 resources trying to help her find a place to move to. So, yes.
I know your position on this, but is it possible the notice is deficient?
Well, let's find out. First of all, let me look at our docket here. Next Friday would be September 5th. What's deficient with the notice?
I am not sure. I haven't seen it, but I do have some notes in front of me regarding this case.
Well, the notice to quit was filed July 16th. No, the complaint was filed July 16th. The eviction notice was something they got off the internet, which looks pretty good. And that was served July 14th. So that may be the problem. The notice to quit was served 2 days before the complaint was filed. No, served on May 10th is what she says. So it was filed at the same time, but it was served on May 10th. That's what my note says. So it appears to be adequate notice.
Thank you, Judge.
At any rate, we're not arguing now about money. This is about possession. If you move and the McLeans sue you for rent, we could have another hearing. That's problematic. A, you've been placarded, so you're not supposed to be renting it. And B, you don't have a lease. So you may just pursue getting the property back and not worry about money damages. But let's see what we got for time for next Friday.
Your Honor,
Now, yes.
I did inform Colleen from the very first day that I couldn't just rent to anybody for any reason because of the zoning thing. So she immediately went right to decorum. I gave her the ammunition. But our apartment is in horrid shape right now. I have a video if we could play it. And my husband's cousin, Sandy McLean Hummel, is here because she was there.
Well, we aren't there yet. We're just about possession.
Oh,
so if you
okay.
get her out and you want to sue her for money damages, you have to file a separate action, probably in small claims court.
But every day that she's there, wow.
Go ahead.
It turns into a mess. She smokes incessantly. It has got maggots hatching out and flies and filth.
Yes, no good deed goes unpunished. So you put her in there, you don't have a lease. She's a tenant at sufferance. I can't just throw her and her baggage out on the street. We have to go through this process. You've been at it since May, and that's really a long time, longer than it should take. You have to give her 30 days notice. Then you filed the hearing in July. I'm sorry, it took all the way from July 16th till now, but I was gone for 2 weeks in July and then I was gone for a week in August at the judicial conference. So here we are in late August. But I have to continue this at least 7 days, and she gets 10 days from that date to move out. So next Friday is September 5th. September 5th is afternoon day, and I would set this for 2 p.m. on 9/5/25 for a second hearing. Now, if you move by September 5th, that's not likely. But if you do move, you need to turn in the keys and give your forwarding address in writing within 4 days of your moving. There is no lease, there's no security deposit. But you're gonna need to get out of there. Now, they've got some concerns about smoking. Is there a smoke detector in there?
We took them all down.
No, I didn't.
All right,
They're
well,
gone.
I don't, so I've got some concerns about fire hazard in a barn, but also she says there's cleanliness issues. You're ready to move. You would like to move, but you haven't got anywhere to move to. And so you've got two agencies working on moving you.
Yes.
And hopefully they can find something. Otherwise, we're going to have this hearing. We're going to address this next Friday by Zoom once again. You're all welcome to come here live, but we'll deal with it next Friday at 2 o'clock. The law requires that I set a second hearing. Didn't used to, but it does now. And then you get 10 days from that date to move, or you'd be subject to being evicted, which essentially gives you until September 15th to move. Or on the 16th, the sheriff could come out and put you and your stuff all out in the street. So that gives you 7 plus 10, 17 days from today. From either of the agencies, do you have any knowledge whether she was paying $1,000 a month rent?
I have no idea, Your Honor. It's just kind of been back and forth. He said, she said. I have no idea.
So Ms. McPherson did provide me with the text communications between herself and Mary since January. An extensive amount of communication where it was indicated and confirmed by Mary in text that she had been paying $1,000. They had an agreement about what the $1,000 would cover. There are some issues that about the notice to quit, kind of all of it. I mean, there's a lot. So
and you're not being picked up very well. What's your concern with the notice to quit?
So the paperwork that Colleen had received, it was back to back to that 30-day notice that said that was sent on May
10th.
Served. On the back of that was a 5-day notice that they served on July 14th. That was the most recent notice. And then 2 days later, they filed the paperwork here.
Yeah, I think the notice is sufficient. If she served one on May 10th, and then she served another one on July 14th, the May 10th one would supersede, and she's got more than enough notice before the complaint was filed. At any rate, she needs to get out. She's not supposed to be living there. They're not supposed to rent it. There's some health and safety issues. There may be some money about whether rent was paid or not, but we're not about money at this hearing. We're about possession. And so once she vacates, if you want to sue her for money, you're going to have to file a small claims case. But since it wasn't supposed to be rented in the first place, that may not go very far. So what you just may need to pursue is possession. All right, everybody on board, we're going to deal with this next Friday at 2 p.m. All right, we'll address it at that time. And you're welcome to come back live again or appear by Zoom.
Your Honor, do you have any need for me to be in that hearing or no?
No, I don't. I do have something that I'd like to talk to you about. Did you get a complaint from a guy named Jeff about a property on Moore Park Road? Excuse me, North Fisher Lake Road?
Not that I'm aware of, Your Honor. I can check with Mike, and would you like to email me an address, or I can contact you later if you'd like?
Yeah, yes. It adjoins my property, so I may, if it comes a case, I'm not gonna be able to handle it. But yes. All right, yeah, I'll talk to you at some point outside of this. Ms. Kirkland, thank you for being here. Mr. Pullman, you don't need to be here next Friday. Ms. Kirkland, I hope you can find a place for her to move to and maybe solve this problem.
Well, we're trying, Your Honor, and I'll be back on Friday as well. Thank you.
All right. From time to time, I do make adult PS referrals myself when I've got people that are in a position where they can't find housing or they're otherwise being left in distress. Problem is, it's so hard to do it. You have to do it through the state central agency, and it's not as clear as it once was. Well, we're a little behind, but let's see who we've got. We've got Mr. Commondike on behalf of Golden Ponds Estates. We got KC Villa. We got Crystal Gray and Crystal D'Amata. Rich D'Amata, which case are you here on?
Should be on mine, Your Honor, I think.
Oh, yes, she is. Calvin Williams and Felicia Wiley. They are not here. So let's talk to Crystal Gray. Let me make a note here. This is 251570 LT. Golden Pond v. Gray. Mr. Kromendijk is here on behalf of Golden Pond, their manager, KC Villa, and tenant, Crystal Gray. All right, Ms. Gray, you're a defendant in a landlord-tenant case. This is a little different than our last case. The last one was the termination of tenancy. This is a demand for payment of rent. In such a case, you have a right to hire an attorney. If you cannot pay for one, the legal aid attorney may be available to assist you, or you could seek some other legal assistance. You have a right to have the matter heard here in St. Joseph County, where the property is located. You have a right to demand a jury trial. If you want to have a jury trial, you must tell the court at this first appearance, or make the demand in writing within 5 days of the court explaining it to you, and pay the $50 jury demand fee unless the judge waives the fee for inability to pay it. As a non-payment of rent case, you may be eligible for some emergency financial assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency that's in Battle Creek, and a housing assessment and resource agency that is Neighborhoods, Inc. Or if you're a veteran, you may be eligible for veterans assistance. You do not need a judgment against you, despite what the DHS might tell you, to get this assistance. You may be able to reach an agreement with the landlord by going through mediation. If both parties, landlord and the tenant, are interested, that's never happened once, but it might, I can refer and help set that up. You may be able to reach an agreement with the landlord that means the case would get dismissed, in which case we would provide, it's called a conditional order of dismissal. This is one of those lot only non-payment of rent cases. Mr. Commondike, we spent a portion of our time at the judicial conference earlier in August on this very topic, whether you can file a demand for rent and lot only in a mobile home park. We discussed this before. I think you sent me a brief from your law firm regarding this. One of the judges in Livingston County shared an opinion where she opined that you can't do it, and she dismissed the case outright. That the only remedy in these cases is the just cause termination for 3 lates in a 12-month period. There is a dispute, and the law is not clear. We need either change in the law, change in the court rule, or a piece of legislation to clarify it, or even a court of appeals case. I've been struggling with it because there's no detriment to the defendant. It allows the defendant to redeem it and keep the property, as opposed to a just cause termination where the only option is to move. And they really don't want the tenant to move because mobile homes are not mobile. Mr. Dutka had represented Golden Pond himself for a number of years, and he's also familiar with this issue. Anyway, it is in flux. So let's assume for the time being that you are able to do this. What is the current arrearage?
Total in outstanding rent and late fees is $1,226.42.
Give me rent.
Yeah, I don't have the full breakdown between rent and late fees. I have the full ledger, but I'd have to go through and do the math to break out the actual rent versus.
What are the late fees?
Let's see. Late fees are being charged at $60 a month.
Oh, you can't do that on a $395 rent.
What number do you go at? 25?
Well, I went with 40 and then I went to 50. It isn't even clear whether you can even charge late fees, but all right, let's use your figure for the sake of argument. Give me your number again.
$60 for late fees.
No, but what's the total?
Oh, the total amount is $1,226.42. That's rent, late fees, some utility fees, some credit card convenience fees. Yeah, and it's composed of kind of those categories there.
Well, we're going to have to break this down at some point.
Yeah,
She doesn't
agreed.
know how much is rent, how much is late fees, how many are the late fees? Can you charge that much?
Yep,
How much
and
are utilities?
I've got a full ledger I can look at with her.
All right. At any rate, we know the bottom line, and then the court costs are what?
Court costs are $249.20.
And what's the total?
That's a total of $1,475.62.
Through August.
Correct.
Miss Gray, what's your intention here?
What do I think? I have it all broke down for you, Your Honor. As far as rent paid and everything, and I dispute the charges, I guess, because I don't understand how it's all adding up. I've paid $19.31, and I should only owe $19.75. So in rent wise, $60 is what I come up with. I just graduated college this month, and I'm planning on getting it caught up as soon and as fast as I can. But I don't understand
how much do you believe you owe $60?
Yeah, with rent, just as far as rent, not including the water that we can't drink or the late fees, the $300 in late fees. And they're also charging us twice to make a debit payment.
Slow down. So you believe you owe $60 in rent. Now, Mr. Duck is aware of this. There's been water problems at Golden Pond Estates for many years. I had a case once where they brought in water from the pond, which was cleaner than the water from the tap. And there were other problems. They put in a septic system, which was actually on the neighbor's property. And this precedes you, Ms. Villa, but a previous owner, they put in a drain field and a septic tank, which was on the adjoining farmer's property. But there's always problems when you have a concentrated group of dwellings flushing their toilets and drawing their water out of the same groundwater source. So there's been problems out there for a long time, but I don't know what the current status is. At one time, the health department considered shutting the place down, but they didn't want to make all the people out there homeless. So I think it's better than it was. An owner made a number of improvements. I think I'm not even sure which generation of owner we're on, but any rate, there's been issues regarding that. So we got a bunch of issues here. She contests the amount of rent owed. We threw some spaghetti at the wall to see if it will stick. I don't know how much is rent. I don't know how much is utilities. I don't know how much are late fees. But Ms. Gray, the law requires that I adjourn this matter at least 7 days. And then there's an underlying issue of whether they can even do this. But let's assume that they can. If they filed a just cause termination, that there were 3 lates in a 12-month period, the only option is for you to move and then 90 days to move or sell the mobile home. So there is some benefit to allowing the landlord to proceed in this way, benefit for the defendant. when emergency funding was available, there was a substantial benefit because they wouldn't give you any emergency housing funds if it was a termination of tenancy. If it was a non-payment of rent, they would allow funds to be used to pay the rent. So, like I said, we've been struggling with this issue for a long time. At any rate, we need to continue this matter to 9/5/25 at 2:15. Now, by that time, Ms. Cromendike, there will be another month's rent due. So you might as well just take that figure of $1,400.75 and add another $395 to it.
Correct.
So I'm disputing that number because I'm probably going to reduce the late fees and I want to see what the utilities are. But 1475.62 plus 395 is 1,870.62. So it'll be about $1,800 that they contend is due. Now,
Chris,
we've got another case to do. I'll call that. Do you think there would be any benefit, Mr. Cromendike, for putting you, Ms. Gray, and Ms. Villa all in a breakout room to try to hash out those numbers?
Yeah, I think that would be great.
All right, Ms. Gray, you stay with me because we have another case, and I'm going to let you guys talk to each other in a breakout room.
Okay, thank you, Your
There
Honor.
does not appear to be anybody here on behalf of Golden Pond versus Fox. This is Golden Pond Estates versus Amber Fox. Excuse me. Try not to sneeze. Again, lot only. Let me make my notes. She was personally served. Let's make sure she's not outside. Good morning. I'm looking for Amber Fox. All right, thank you. She's not here. This is also a non-payment of rent case. The defendant was personally served. What's the arrearage here?
Total rent, utilities and late fees is $1,926. I again would note that we are going to have the same late fee issue as we did on the last one, and I'd be happy to give you a full breakdown after. I'll reduce the late fees down to 40.
Okay.
That number may go down, and then court costs are $273.69. And so that's a total judgment amount of and amount to retain of $2,199.69.
How many late fees are in there?
Let's see. Let's see, 1, 2, 3, 4, 5, 6, 7, 8. Well, it's hard to tell because the balance has not been zero since for over a year ago. There's been a running balance since at least June of 2024.
Late fee is $60 in the lease. I'll allow 50. Says lot only.
I will adjust that based on the $50 number.
So it sounds like it'll be reduced by about $100. She's not here. She was personally served. Is Miss Via, is she still there? Your microphone is on.
She's still living in the property.
All right. All right, by default, I find that the defendant owes, I'm just gonna put a number on it, $1,826. I reduced 10 late fees. $273.69, total of $2,099.69. They have 10 days from today to pay the rent, or the mobile home is subject to being moved. And it's her house, and this is mobile home only. So this is where the problem becomes, because no one ever moves a mobile home. I don't know why she's not here. The date for the writ is 10 days from today, which would be, today is the 29th. It would be September the 8th. All right, I'll need a judgment. You can email it to me at the address on the notice, which is 3B Civil at stjosephcountymi.gov.
I will get it into you this morning. Thank you.
All right, I don't know. The judge who wrote the opinion in Livingston County was very well analyzed. I've received two briefs, one from, I think, the Cox firm and one from another, where they argue that you can do this. We'll see. But now you've got your judgment, and you got to figure out what you're going to do about moving this mobile home. So generally, the thing works out somehow. We'll see where we go with this. All right, she isn't here. She's subject to default. Now, we have our other Golden Pond case that we addressed, Miss Gray, and I'm going to put all the parties in a breakout room to discuss narrowing down those figures. So, Miss Gray, when the button to hit join comes up, you join. I'll be here if you need me further.
Do you want us to come back in to talk to you when we're done, or
if you need to? Otherwise, if you're done, you can all just go, and I'll see you next Friday.
Okay. Thank you.
All right. Thank you.
Thank you, Your Honor.
Thank you. All right. We're behind, but sometimes that happens. Maybe we'll get caught up. Miss Fox didn't come. We've done 3 cases. Our next matter is Mr. Dutka's. It looks like a default. The title of this case is Crystal DeMata versus Calvin Williams and Felicia Wiley. This is a demand for non-payment of rent. Rent is $1,900 per month, which is pretty high for us. This is a house at 123 South Constantine Street. Both defendants were personally served. The rent arrearage is substantial, $7,070 plus utilities. Mr. Dudka, what's the current status?
Right now, Your Honor, and my client did furnish me with an updated spreadsheet. I know the court doesn't have it, but right now, August rent was not paid, and she received the sum of $230 toward the water bill. And we're showing rent plus utilities of $9,206.25.
How much is rent?
How much is rent on that is going to be $8,970.
And utilities?
Utilities would be, let's see. Looks like $236.25.
Well, it was 466.
Right.
So is that 466 plus the new figure?
That's 466.25 minus the 230 she paid.
Okay, so how much is utilities?
236.25.
And then how much are the court costs?
Court costs I'm looking at filing, service of process, and attorney fee. We're looking at $236.98.
$8,970 utilities, $236.25. Court costs $236.98. What does that ought to add up to?
Let's see. That I didn't. Yeah, that one I didn't add up. I should have.
Well, let's see if we get the same number, 236.25 plus 236.98 is 9,443.23.
That's what I have.
Let's check and make sure they're not here. Whoops. This time I'm looking for a Calvin Williams or Felicia Wiley. Yep. All right, thanks. Bye. They're not here. So they are subject to default in that amount. They have 10 days from today to move, or they're subject to being evicted, which would be September 8th. That's a Monday. No money judgment is entered this time. Partial payment will not prevent the writ of eviction. Ms. D'Amata, are they still there?
I think she might be muted.
Yeah.
Oh, there you are.
Are they still there? I can't hear her. Nod your head. Are they still there?
There we go.
Well, they're way behind in the rent. It was a lease through 2020, and then it became month to month. $1,900 monthly rent is, excuse me, is high for our part of the world.
And another rent payment's due Monday, but it's neither here nor there.
Yeah, I'm not allowed to add the next month into the equation.
Correct.
All right. They are subject to default. After the 8th of September, you can ask for a writ of eviction and proceed accordingly. All right.
Thank you, Your Honor.
Thank you. All right, how are we doing for time?
She just called in,
Oh, poop.
claimed she couldn't get into Zoom. She called.
You've got
I didn't take it.
Golden Pond versus Amber Fox. All right. tell her this. Shows $2,099.69 in rent.
Okay.
She's got 10 days to pay it. We'll see if she wants to move to set aside the default, she can do that. I'm gonna try to reconvene it. All right, now let's see who we've got. Mr. Thornton is here on Sturgis Place Apartments. Maria Matson, the manager for the time being, is present. We've got two cases. Mr. Thornton has dismissed one. The next matter, Sturgis Place versus Goodrum, is set for 9:40. It's 9:48. So let's see what we got. All right, now I'm looking for a Christina Gundrum or Cody Fultz. All right, thank you. Bye. They're not here. This is filed as a demand for non-payment of rent. Each defendant was personally served. And Mr. Thornton and Mr. Bush and a couple of others provide me with these judgment information reports, which makes life much easier. One of the attorneys couldn't tell what was rent, what was late fees, what was utilities, and we end up chasing our tails. Anyway, in this case, Mr. Thornton has provided that information. July's rent, a late fee of $100, which we can't do. 50. July utilities and September utilities, we're going to allow September in there because it's easier. So the total of rent would be $2,520, $156.44 in utilities, and $237.40 in costs, for a total of $2,913.84. Does that match what you have? If I take $50 off of each late fee?
It does. And Maria had indicated to me yesterday that they were seen moving things out, but I'm assuming that Maria has not received the keys back yet. So.
No, I have not received keys. They are here. My staff told me that they're at the apartment moving the rest of their stuff out right now.
All right. Well, I'm going to enter this default through August. Rent is $2,520. Utilities are $156.44. Court costs are $237.40. This is by default as to both parties. $2,913.84. The defendants have 10 days to vacate or they're subject to being evicted, and it sounds like they are vacating. That would be September the 8th. Partial payment will not prevent the writ of eviction, and no money judgments is entered at this time. And the appeal date is also September the 8th. All right. They're moving. The issue there will be trying to ever collect any money. I've got some people that are coming in here by telephone. Let's see what we've got. All right, so I'm going to call Mr. Thorne's next case, Sturgis Place Apartments versus Caleb Baum. File number is 251631. They have filed a dismissal without prejudice. I don't know if that means they paid or they moved, but I'll sign that. And then it looks like you're good, Mr. Thorne. I'll see you this afternoon. Let's just make sure who the phone number is.
Okay.
I've got someone here. The phone number ends in 4868. Who am I speaking with?
Charles Huber.
What's your name again?
Charles Huber.
All right. All right. You're good to go, Lance.
Okay, thank you, Your Honor.
I'm going to do my usual segue into general civil matters, which is always a problem. But let's see what we've got here. Grant v. Ballard is set for 10:50. But everybody's here. It's 9:50. I guess that's the next one we've got. Kyle Grant versus Danielle Ballard and Danielle Ballard. All right. Mr. Grant, can you hear me?
Yeah, I'm sure you can.
Miss Ballard, can you hear me?
Yes, I can.
This is another one of those evictions where the parties are in the same house. A Pulver Road address. Mr. Grant has served a notice to quit on the defendant some time ago, and once Miss Whoa, sorry about that. Miss Ballard, Mr. Grant wants you to move. What's your position there?
I have no place to go. Yeah, I've been looking since he gave me the 10-day to quit for ever it seems like for a place to stay.
Yeah, the notice to quit was served on July 3rd.
Yeah, when he tried to give that to me,
I lost her. There she's back.
yeah.
All right, he wants you to move. You haven't got anywhere to go. Was there ever any rent? Oh.
No, we had a verbal agreement for exchange and work to organize and clean up his yard, in which I was doing until they started sabotaging me.
The verbal agreement is not worth.
And shut the power off. And
all right. Well, are you all living in the same house?
he lives inside the house. I live above the garage.
He shut the power off?
Yeah, the lady in the house decided that she didn't want me there, and she cut the power wire to my room from the breaker box. She then steals my generator that I was using for power, shuts the water off to the water spigot outside, locks me out of the house so I can't use the bathroom. And I mean, this is ongoing. I've even made police reports about this stuff. And
All right, well, let me stop you.
then I get two.
Stop.
Oh, sorry.
Stop. All right. He can't do that. But you can't live here. He wants you to move. You don't have a lease. You haven't moved because you got nowhere to go. So you're in a deplorable circumstance. You're not paying any rent. You're living above his garage. And somehow that is our lot in life. You need to get out of there. Mr. Grant, you can't shut off her utilities. You can't turn off her power. You can't turn off her water. And you can be subject to the lockout law, and you can end up paying her money. Miss Ballard, are the utilities working now?
Yes.
Have you made any effort to find a place to go to?
Yes.
Any luck?
I'm sorry, my phone cut out. I've been trying to find a place since, like I said, since he asked me to move out. I just haven't had any luck. Nobody has a room available.
Well, right now your rent is zero, so you're not going to beat that, but you can't stay there. This probably isn't even a lawful dwelling. We had another case in Fabius Township. This is Fabius Township, where someone's renting an apartment above a garage that they really can't do. Mr. Grant, how did she come to be in there?
She was basically in the same situation when she had nowhere to go. And I was nice enough to let her, at least I told her she could stay there until she can find a further place to live. And then, of course, she did yard work and stuff like that. And she did fine with all that stuff. But like I say, there was just an incident that happened with it because she wanted more than just the one room that I had upstairs. And I built it for storage. And so anyways, she cleaned everything out of there and took it downstairs. And some of the stuff wasn't mine. And of course, the person that I got living with me, it was her stuff. And so I got yelled at for that. And I'm getting it from all directions. And I'm done with it.
Well, Miss Ballard, as a practical matter, you probably can't even live here. If the township was clued into this, they would probably condemn it. So, but your friend can't cut her power. I don't want you running this on a generator. That's a
right. Yeah, that's not happening. Like I say,
as soon as I have to
the power, I turned it right back on, and everything is, the water, same thing. So that's not an issue.
I'm going to continue this to September 5th. That's next Friday at 2:35. Now, we're going to revisit this next Friday at 2:35. If he gets what he asked for, which I'm inclined to give him, you would have 10 days from that day to move out, which would be the 15th of September. But you can't continue to stay here. There's no lease, there's no rent being paid, and it's probably not a lawful apartment to be rented. So I hear it all the time. I'd move if I had somewhere to move to. Right now, your rent is zero, and you're not going to find any place where your rent is zero. But it just is what it is, and you know it. You'd move if you had a place to go to. You don't like it there either. But this forces the issue. People would never move. I haven't ever moved to. 9 years later, I haven't found any place to move to. That's what this proceeding is about. It forces the issue and compels the people to move. And if they don't, then the sheriff moves it for them. So Miss Ballard and Mr. Grant, we're going to address this again next Friday at 2:35. Ms. Ballard, do you have any questions?
No, sir.
Okay, now if you do move, you need to turn in the keys and give your forwarding address in writing within 4 days of your moving. There is no lease, there's no security deposit, but that's what the law requires. All right, hopefully you can find a place to go, Miss Ballard, because we can't continue on like this. All right, I'll see you both next Friday,
At 2:30, you said?
2:35.
2:35.
But
Okay,
2:30 is fine. All
Okay,
right.
thank you.
Remove her. All right, now, what time is this? 10:25. So I've got a couple of general civil matters, and I've got a couple Whispering Pines cases. So let's talk about our general civil cases. And I always, it's like fingernails on a chalkboard every week. I'm in the middle of the landlord-tenant docket, and I've got 3 thorny general civil cases. But let's see what we've got. We've got Optalis versus Charles Huber. Mr. Huber is here by telephone only, which is not ideal. And attorney Titus O'Donnell is here in that matter. Prestige Financial is present and Dustin Stafford is present. And Portfolio Recovery is present, but Michael Lord is not. That'd be Mr. Duquette. Well, let's take up the attorney fee case, and then we'll probably do a default, and then we'll deal with Staffords. This matter is Optalis of Three Rivers versus Charles Huber. The file number is 251141GC. A default judgment was requested. Mr. Huber was sued for $8,166. Court costs were $161, and plaintiff is requesting $1,095 in attorney fees. Statutory attorney fee in this matter would be $75. So the clerk flagged this for a question regarding attorney fees. Mr. Huber, can you hear me?
Yes, I can, sir.
And Titus O'Donnell is here. Mr. O'Donnell practices in Ohio, but he is also licensed in the state of Michigan. Mr. O'Donnell, what can you tell us regarding the reason why I should supersede the statutory attorney fee for that amount?
Thank you, Your Honor. Titus Donnell, P87307 on behalf of the plaintiff. This is a nursing home bill, Your Honor. And in the contract, there is recoupment of attorney's fees for all collection efforts. So that's why this got requested, is pursuant to that. If the court is not inclined, then we would withdraw, and I'd be happy to resubmit
I could just do it. I don't have the contract.
It was attached to the complaint, Your Honor.
Let's take a look. Mm-hmm. Well, it looks long, so complaint.
It's section 4A, Your Honor.
Residents' responsibilities, you pay us room and board rate, any additional ancillary charges accrued by you while in the facility, any co-deductibles, any additional denied charges not covered by insurance, You will pay for these collection costs. Now, is that the section number 5?
That's correct, Your Honor.
All right, I'm gonna go with the statutory, a fee of $75. I will enter the default. Mr. Huber, you got served with this lawsuit. Didn't answer the lawsuit, so they entered a default judgment. I set this hearing just because I was concerned about the amount of attorney fees. I don't feel that section is sufficiently clear to inform people of the fact that they would have to do this. Plus the statute says the party's entitled to a rinky-dink $75 statutory attorney fee. So 8166.66 plus 75 plus 161.43 in cost is $8,403.09. I've altered the amount and I've signed the judgment. Now, Mr. O'Donnell's firm is located in Columbus. Their number, contact number, is contained on the pleadings. So I suggest when you get this in the mail, that you contact them and discuss setting up some sort of repayment plan before they start a garnishment of their other collection action.
Your Honor,
Yes.
I'm on disability.
Yeah, if you
I
don't
get
have
paid
any
once
money,
a month.
you don't have any money.
That's how I get paid once a month. And
Yes, you're probably what's
2000.
called. Go ahead.
I've had cancer twice. I lost my wife 2 years ago from cancer. And the reason I ended up over at Rears is I had a blood clot burst to my leg. I couldn't feel anything. I had to be rushed to the hospital by ambulance. I was in Kalamazoo Hospital for 3 weeks in a coma. I was then put into that nursing home, which I wish you could take a drive and stop in and walk through that place.
I've been in it. All right. Well, none of those are for me to decide. You were placed in there. You signed a contract. They provided services. You didn't pay the bill. Wasn't covered by insurance. I did reduce the attorney fee by almost $1,000, but you're not presently in a position where you have any money to pay this. Your circumstances could change. You could win the lottery or inherit $1 million or something. But at this point, your medical story is certainly one of struggle, but it isn't a defense to the fact that you owe the money, but you don't have any money to pay it. So they probably are not going to be able to collect on it, but you got sued. You didn't file an answer. The time frame passed. So you're subject to default. I was here just to question the attorney fee and I reduced it substantially. And I guess that's the best I can do, sir. You'll get a copy of this. Are you at the Congress Street address?
Yes, I am, sir.
All right. Anyway, once again, their contact information is on there. You can contact them, but they can't garnish your disability. And if you don't have any money, you don't have any money. Mr. O'Donnell, thank you. Your boss probably won't be very happy with my ruling or the client, but I reduced it I entered your default effective today, which would be 9/8/29/25. All right, thank you. You're all good to go.
Thank you, Judge. Have a great weekend.
All right, we're working on
Thanks.
it.
Have a great
Mr. Huber, good
great
luck.
weekend, Your Honor.
All
Thank
right.
you.
Well, I'd have a great weekend if the sun shined and it was 80, but we'll do the best we can. TJ, I've got a couple more general civils in here.
Not a problem.
We'll get to your two cases. We also have portfolio recovery versus Michael Lord. Mr. Duquette is here. This is defendant's motion for installment payments, and he isn't here. Good morning, Mr. Duquette.
Good morning, Your Honor.
We've had several hearings in this matter. The debt is $5,497.61. It's probably altered with interest. Defendant filed a motion for installment payments of $100 a month. Plaintiff filed a written objection and the defendant didn't show up. So we're just gonna chase our tails here. How much would the plaintiff accept?
We were requesting $230 a month, which would pay the judgment balance off in about 2 years.
All right, I'm gonna do that. I'm gonna order $230 every month, starting October 1. Defendant failed to appear at hearing. All right, we'll see how that flies. He probably won't like that much, but he isn't here to defend it. Rather than just deny his motion outright, I set the amount at what plaintiff will accept and see how we do with that. Thank you, Mr. Duquette.
Thank you, Your Honor. Enjoy your
Looks
long
like
weekend.
you're in the blue void there with the background you got. I hope you don't fade away. All right, thank you. I'll see you next time.
All right, have a good one.
All right, that leaves us with Prestige Financial versus Dustin Stafford. And somebody is here for Prestige. I can't yet determine who it is.
Good morning, Your Honor. Jay Lazar on behalf of the plaintiff, P69480.
All right, give me that again.
Jay Lazar on behalf of the plaintiff, it's P69480.
I can't see you. Can you turn your camera on?
Yeah, I'm working on that. I'm sorry. I'm having some sort of internet problem with that.
All right. Well, this also is a motion for installment payments. The debt here is significant. It's over $20,000. Defendant filed a motion for installment payments. He wants to pay $75 per week on a $25,000 debt. Mr. Stafford, the interest on this is probably $75 a week. Mr. Lazar, what's your position?
Your Honor, my client's position is, again, there was no willing attempts at payments on this until the garnishment was filed and hit. Again, it was quite a number of years from the filing. I believe it was in 2023 at the beginning of the year. So it's been close to 2.5 years with no willing payments. He did make an offer at one point. We accepted. No payments on that offer ever came in. So it's not so much a matter of the amount. It was just that when he was on a willing payment plan, he never made any payments. It looks like there was similar issues with our client before they turned the file over to us as well. So willing payments from my client's perspective haven't really gone anywhere. Plaintiff would like to keep the garnishment in place. If Your Honor does grant an installment plan, which we understand will probably happen, we do note that it looks like there's close to $900 every 2 weeks or so coming in on the garnishment. So taking that in mind, along with the amount of the debt and how long it would take and the interest to make this productive, it's not so much if an installment plan is granted. We would ask that closer to around $150 a week would be asked.
Your Honor?
Yes, I hear you.
When I talked to the attorney, the gentleman who's talking, when I told him I was going through a messy custody battle, messy divorce, and I told him I could afford $100 a month, he told me that his company would not accept that at all. So for him to say that I was willing to pay $100 a month, but he told me no.
Let me
my
stop
14-year-old.
you, Mr. Stafford.
Okay, sorry.
$100 a month won't even pay the interest on a $25,000 debt. So
I understand that, sir.
It's not enough. So you've mostly ignored this until they started a garnishment where they take a large chunk of your pay, and then you filed this motion. So $75 a week is better than $100 a month. But right now they're taking a big chunk of your paycheck.
Yeah, I know. It's a struggle.
And you are going through a divorce and custody battle. And
no, the divorce is finalized.
All right.
But at the time when he served me the papers, I was sitting in jail for doing weekends, and I got the paper. I called him that following Monday as soon as I got out on a Sunday, called him up, offered him, and like I said, he said no. So I was like, okay, well, what the heck am I supposed to do then? And then went about my business. Then I went into work one day working at the Constantine Flooring Center, and my boss was like, hey, do you know anything about this? I was like, yeah, I tried to set something up a year ago, and I got told no, so I'll deal with it. So then I wrote into the courthouse and asking for the payment plan, and I wrote down all my bills.
Well, you make it sound like, hey, I want to take care of this. Yeah, I want to pay $1 a year on a $10,000 debt, which will take 10,000 years to pay off the debt. Correct. Your offer of payment was less than the interest. So you were just going to get farther behind. So that's why they said no. I'm going to try to come up with something that might get us where they want $150 per week. You want $75 a week. You actually want $100 a month. Would you rather?
No, at the time it was $100 a month, sir.
Yes. Would you rather do it bi-weekly or every week?
I get paid weekly, so every week would be fine.
$100 a week starting October 3rd.
Now, do I mail that to them, or is it just going to continue to come out of my check?
Well, it won't be a garnishment. It'll stay the garnishment. So you're going to have to set up a payment plan with them. Maybe they can do a automatic wage assignment from your check, but it's less than they want and more than you want, but it will pay about $430 a month, give or take. $100 a week isn't the same as $400 a month. There's 52 weeks in the year. So you're going to pay $100 every week directly to them. And what I would suggest you do is go into your payroll and set up a wage assignment.
Okay.
All right, $100 per week.
So does the garnishment stop, Or do
Yeah,
or does it stop
this-
after?
This will stop the garnishment. Any
Okay.
funds that have been garnished can be applied to the debt, but they're probably in
Okay.
limbo right now. But yes, effective today's date, which is 8/29/25, $100 per week starting October 3rd. That's the first Friday in October.
Could I get the attorney for Prestige? Wait a minute. Okay, I got the phone number. Jay, do you mind if I call you so I can get an address or some way to?
I can put you
set up
guys in a
payment plan?
breakout room right now.
That's more than fine, Your Honor. The phone's easier anyway. If he wants to call me, then Mr. Stafford, I see you're a little riled up. I apologize. I don't think I myself have ever talked to you. By all means, call me at the office. I'll give you all the information you need.
Yep. Will do. I'll call you right now as soon as we hang up out of here.
Perfect.
Appreciate it, guys.
All right,
Thank you so much.
Thank you, Your Honor.
All right. Now that
Everybody have a nice Labor Day.
All right, we're working on it. All right, Mr. Reed is here. Ms. Lentz is here. Nobody else is here.
I got Robert in my office with me and Margaret. Colonial wants to be one.
All right, well, let's talk to them. This is file number 251499LT. It's entitled Colonial Estates versus Robert and Margaret Wedland. Rebecca Lentz, the manager, is here. The defendants are in the office with her. Mr. and Mrs. Wedland, can you hear me?
Yes, we can.
All right, Mr. Timothy Reed is here. We learned a lot last time we were here. This is another one of those lot-only cases that we struggle with.
This is lot and rent, Your Honor.
Oh, yes, it is. It wasn't clear. Lot and rent, and the rearage was, I think, 3186 was the total. What's our status here today?
From my understanding, Your Honor, the total amount there has been a payment made is $2,186.86. And that included all the court cost of the court cost, service fee, and filing fee of $209.30.
All right, well, I gotta back that out. How much is rent?
2,000. Hold on, we did that last time. It was of that dollar amount, Your Honor, $2186.86 less $209.30.
This is a hard way to do it.
So $1,977.56 is rent. Well, and 160 of that is trash fee, Your Honor.
Rent and trash. 160 is trash?
Yes.
All right. 1977 minus 160 is, oops. $1,875.66 plus trash 160, trash delivery, and 209. How much for the court? 209.30.
Yes.
Gives us 2,186.86.
Yes, sir.
Which is, yeah, all right, well, let's do it that way. All right, Mr. and Mrs. Wedland, what's your position?
Well, we did pay $1,000 payment.
Mm-hmm.
So that would come out of that. And I have 3 organizations that I'm working with to get assistance with the past due amount.
Okay. Are you getting any help from the VA?
Well, that's one of them that we're dealing with is the, what is that called?
American Legion. They have to turn in paperwork.
And then the other one is in fact, there's two more. The other one is the agency that I was called twice a day.
Community action.
Yeah, community action. And I finally did get an appointment they're sending me the paperwork to fill out to send to them. I've been calling them twice a day and they haven't had any openings. And then the other one is
now on September 1st, another month's rent and lot rent are going to be due.
Yeah.
So this figure is only through August.
Yeah.
So I wish I could include it because it would be helpful when you're asking for emergency financial assistance. But rent through August is $1,875.66. Trash is $160, and the court costs are $209.30. So the total is $2,186.86. You have to pay that within 10 days, or you're subject to being evicted. 10 days from today is September the 8th.
Well, the organizations I'm dealing with.
Let me tell you some more. Ms. Lentz knows this. She's been around for a while here, and she's worked with lots and lots of tenants. She doesn't have to evict you on September 8th. She has 56 days from today to ask for the writ of eviction, and actually another 56 days to serve it. It's much easier to keep a good tenant in there than to move them out, particularly in a mobile home, because they would have to move the mobile home. So it's in their interest to get the rent paid. But I need to tell you that a partial payment will not prevent the writ of eviction. So the monthly rent and lot fee is how much, Mr. Reed?
I'm sorry, Your Honor. It is $709 a month. Is that correct? Plus, there's a pet and trash fee of $40 extra, but the base rent is $709.
Yeah, so they pay $749.
All right, so next September 1st, you're gonna owe an additional $749, which is gonna make this about $3,000. So let's say that VA and American Legion, and they all give you $2,500. You still are gonna owe the balance. So you need to stay in good contact with Ms. Lentz. And they're going to share this judgment with these funding agencies and see if you can get some emergency help. Do you have any other source of income?
Just what we get every month.
Well, do you have Social Security?
Yes.
And a pension, or just Social Security?
Well, a pension is only.
I got a pension of
100, is it?
130, and another pension for 170.
All right, so that's 300. So you have some money coming in, your pensions and your Social Security. So you've got money, and if you get financial help, maybe you can get squared away. But
that's what we're hoping.
Well, I think that probably somebody's going to give you some help, but you have to pay the entire amount. And bear in mind, September 1st, another $740 is going to be due.
Yeah.
Mr. Reed, do you have anything to add?
I do not, Your Honor. We'd sent judgments over yesterday or the day before with.
Yeah, I have them.
Okay.
All right. All right. We'll send a copy of this. You stay in contact with your manager. All right.
Yep.
All right. You got good contact. And again, she knows how this works. She's very experienced, and I'm sure she'll continue to work with you.
Oh, they've been really good about it.
All right. You're good to go. Thank you.
Thank you.
Our next one is Whispering Pines versus Eastman and all other occupants. defendant failed to appear, but we did not have personal service. So we continued the matter until today. Ms. Lentz, do you believe Mr. Eastman is gone?
No, they're still there.
Have you had any contact with him?
She made a payment yesterday. His wife did, $500. She said that she was going to pay the rest by this morning before court. I told her what time it was. She said she wouldn't be on court, and I did not get the payment before court.
All right, so last week, the payment through August was, or the amount was $1,113.50. So we should deduct 500 from that?
Yes.
Yes.
All right, 1113.50 minus 500 is $613.50. Plus 179.10. Is, that's not right. 613.50 plus 179.10 is 792.60. We'll do a default in that amount.
All right. And you have that judgment as well, correct, Your Honor?
I do, yes, thank you. And then again, this is through August. It's always an issue at the end of the month. Rent is $613.50. It sounds like they're going to certainly get it caught up by the requisite date. Court costs are $179.10. The total judgment out of $792.60. Not overwhelming. That's due by September the 8th. Partial payment will not prevent the writ of eviction. And the date for the appeal is also 9/8/25. All right, it's helpful to have those judgments, Mr. Reed. Thank you.
Yep, you're welcome, Your Honor. And of course, these numbers came in, as like Rebecca said, payments yesterday and a couple days ago. So we just have to leave them blank so we know the morning of.
Yep, that's fine. That's fine. All right, that finishes that. I've got a criminal matter to address. Mr. Stickley's here to help me with that.